Oda from the state of Ohio.
Yes, Your Honor. I know the recommendation from probation is for him to receive residential treatment. However, Judge, what concerns me about Mr. Bailey
basically piggyback off the same thing. We've already briefed this exact same issue. The court has already rendered its ruling designating the time that these attorneys' fees were to be charged. And so I'm not sure why we're rehashing that issue when we already have the order on that. My understanding was we were to be here to discuss, as you mentioned, the reasonableness of the attorney's fees.
It also seems like we're diving into attorney-client privilege that is unrelated to the issue of the attorney fees.
I don't want to ask anything about attorney-client privilege, Your Honor. I have a couple more questions about the setup for the deposition, and then I'll get to the affidavit.
Okay, let's go ahead and ask a different question then.
Do you know, Mr. Lynch, who did notify ICE to be there at the Golden Lamb on the day the deposition was scheduled?
I have no knowledge.
It wasn't you, though.
No.
I'd like to look at the affidavit that I handed you. It's Plaintiff's Exhibit A. And as I mentioned earlier, what I did was color code some of the entries I'm going to be asking about. I was trying to figure out an easy way to get through this efficiently.
Hold on, counsel, I'm confused. So we have defendant's notice of video deposition of corporate representative sub corporation, which is an unfiled notice, which is A, right? So then we have supplemental affidavit of John Dunn in support of attorney fees, which is not actually what was filed. It is a modified version of what was filed, which we're going to call B, right?
You're right, Your Honor. I'm sorry. This is B. This is defendant's Exhibit B, which, as you state correctly, it's a modified in the sense I've highlighted some entries. Other than that, it's identical to defendant's Exhibit 1.
Okay.
So, Mr. Lynch, I'm looking over the affidavit and your entries, and I see you've redacted entries that don't have anything to do with this case. Is that what the redactions are for?
No. The redactions, our understanding was we were to submit time entries associated with anything with the deposition, the notice for sanctions, our motion for sanctions, the client communications concerning those motions or the depositions, and the ultimate hearing. So at the same time, a lot of the pretrial work was being concluded. We did not add that time as billable time that we are trying to receive from the court in this hearing.
Thank you. And as I look over the entries, I see I've color coded the entries in yellow. There's many entries for conferences and communications with another counsel, Mr. Fisher,
That's correct.
and you believe those should be compensable here at this hearing.
Correct.
You really need two law firms involved to work up these motions and accomplish these tasks.
Well, the motions were inextricably intertwined between the counterclaim against Select and Select's claims against veterans. And so the motions that we have impact for both cases. And so to essentially put up a firewall between the two, one, would be impractical, but two, wouldn't allow us to adequately represent our client.
Well, who prepared the motion for sanctions?
Mr. Dunn and myself.
Not Mr. Fisher, right?
That's correct.
And then I see,
Let me correct that. We prepared the motion. I don't know what Mr. Fisher did or did not do. I'm aware that he reviewed it. But to my knowledge, we were the ones who actually wrote those motions.
I've also color coded in blue, and the first of these entries, I believe, is at page 13. There's several entries for conferences with a person called Brandon Thibodeau, Thibidoux. Let me know when you.
I see them.
He's not counsel of record in this case, right?
No, he is not.
And not an employee of Veteran Logistics, right?
No, it is not.
And not a lawyer or employee at your law firm, right?
No, he is not.
Well, that shouldn't be compensable here then, should it?
I would disagree with that. It is communications with the claims representative on this case pertaining to the motions and sanctions that we were seeking.
I thought your client was veteran.
Our client is a veteran.
There's a couple entries here, Mr. Lynch, and the first one is at,
What page are you on?
I'm trying to see a page number on this. There's page 14, there's a blank page, and it's the page after the blank page,
Okay.
which is not numbered. There's an entry here related to an outfit called Carrier 411. We somehow had a guy up at the Golden Lamb videotaping ICE's apprehension. Could you explain this entry of December 1st, 2025 of yours?
Yes. So the response memoranda to the motions for sanctions included insinuations that we had told our client or somehow coordinated with our client to coordinate with ICE to facilitate the arrest of Dimitri Sayudin. Not only was that entirely false, it was completely contradicted by the X files that we had seen on Carrier 411's Twitter page. And so in preparation for that hearing, and to combat those possible arguments as laid out in the briefs, we undertook a analysis of those files and of his videos that he had taken, the statements that he had made, to bring those to the court to show that this had nothing to do with our client if necessary.
And what was the conclusion of that analysis?
It appeared that Carrier 411, based on the statements that I recall he made in the videos that he took, that he was the one who facilitated that.
He somehow, your conclusion was he somehow found out how about the deposition?
I have no idea how he found out about the deposition. My conclusion was based on the statements that he made in his videos that were on X. But Your Honor, if I can put my attorney hat back on, I don't know what this has to do, these questions specifically have to do with the reasonableness of these fees.
It's sort of related, so I'm going to overrule the objection, but let's bring this part to a close.
All right, I still don't understand how it relates. to the fee award, you concluded, you analyzed some social media reports and concluded that this person from Carrier 411 had somehow found out about the deposition. How?
That wasn't my conclusion. The basis for this time entry was to combat Select Corporation's insinuations throughout its brief in opposition to our motion for sanctions that Veteran Logistics had some sort of play or involvement in this. What my testimony is that I have no knowledge of that. What I do know is that I personally saw Carrier 411's Twitter page and the videos that he posted and the statements that he made insinuating that he was the one responsible for that.
Responsible for what?
For the detention or arrest of Mr. Sayuddin.
And was your conclusion that neither you nor Mr. Dunn had told this guy from Carrier 411 about the deposition taking place?
I could only speak to what I said or told anyone, and I have never spoken with the person from Carrier 411.
And you last question on this, you don't know if your client spoke to the Carrier 411 person,
I
right?
have no knowledge.
But you concluded that he somehow got up here on his own.
I concluded based on the statements that he made in the video, or multiple videos that he posted on X, that he was the person involved. And again, this was to combat the insinuations raised in the plaintiff's briefs.
And then there's one other, and this is the last entry I'm going to ask about. January 7th, so it's not numbered, but it's the page right before Exhibit B. The January 7th entry again for you, Mr. Lynch. Could you explain that entry, please?
I would give it the exact same explanation that I previously gave.
So another hour and 1/10 worth of analysis for why?
In preparation for the hearing on Veteran Logistics' motion for sanctions.
And you hadn't concluded the analysis before,
Apparently I had not.
because you said you had, and you already come to a conclusion. So
Right, so these are two different things. So we analyzed it once in preparation for the response and or reply in support of our motion for our motion for sanctions, and again in preparation for the oral argument.
and why did you need to analyze them again?
Well, if you go back, these are a month apart. I mean, I never took a transcript of what those documents were or said. So I think it would be prudent to bring myself back up to speed if we needed to broach that topic at oral argument.
And what conclusion did you draw from that analysis?
The exact same that I previously gave.
Which was?
Which was that the Carrier 411 individual was or appeared to be responsible for that.
I'm not sure I understand that. Who appeared to be responsible for what?
For the arrest of Dimitri Sayuddin. But I shouldn't even say the arrest. Probably more precise is the coordination with ICE and or Homeland Security.
And did you make a conclusion as to whether your client had any involvement in that?
As I previously mentioned, I have no knowledge of what my client was or was not involved in.
Just a couple more entries I have questions about. November 17th, and I'll call out a page number when I get there. And they're highlighted, I think, in pink. Page 9,
At the top,
right. Mr. Lynch, you're aware that per Ohio Rule of Civil Procedure 5D, deposition notices should not be filed with the court?
personally, I'm not aware of that rule. I don't disagree that it exists. That is knowledge to me.
And if that is the case, then the filing of the notices was unnecessary. Would you agree with that?
I don't know that I would agree that it's unnecessary. I mean, I think it's a standard practice, at least at the 3 law firms that I've worked at, that has always been the case.
You've always filed deposition notices.
I believe I have.
Do you agree with me, Mr. Lynch, that if ICE hadn't been alerted somehow to show up on November 21st, 2025, Mr. Kuden's deposition would have taken place?
It could have taken place.
What do you mean by that?
I mean, nothing is for certain, right?
You agree that he was there, his counsel was there, a court reporter was there, lawyers for veteran were there, right?
I was not there, so I have no personal knowledge as to who was not there. Again, as I previously testified, my understanding is that Mr. Dunn was there, and I believe Mr. Lacey was there, and that was the extent.
And Mr. Kuden was there.
Mr. Kuden appeared.
What's the difference?
His deposition wasn't taken.
But he was there at the Golden Lamb, right?
He was on the premises, I believe. Again, I was not there. I have no personal knowledge as to where he was, when he was anywhere.
I'm sorry, did you say you don't know if he was there or not?
It is my understanding that he appeared on the premises as I previously testified.
And if his deposition would have taken place, you agree with me that none of these entries would even be on your timesheets, right?
I mean, it's a speculative question, but of course, if his deposition had taken place, I would not be here at all.
Thank you, sir. I don't have any further questions for you.
Anything that you want to provide me by way of evidence, narrative, in terms of evidentiary materials?
Other than the affidavit, Your Honor, no. What I would just object to is, again,
Okay, well, I just need to know if you have anything left as a witness.
I do not, Your Honor, no.
You can,
Thank you. Does the court have copies of these?
I do.
Okay.
I am going to make you send me all of these electronically, though.
I will do that, Your Honor.
Okay.
All right. What else, Mr. Zaloon?
A couple quick questions for Mr. Lacey, Your Honor.
Okay. You swear or affirm the testimony you'll give in this hearing will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, have a seat.
Mr. Lacy, I'll wait till you sit down. Are you one of the counsel who has represented Select in this case?
I am.
And have you attended hearings in this case?
I have several, including the oral argument on the motion for sanctions back in January and the final pretrial in January as well.
And were you there at the Golden Lamb on November 21st, 2025 in the morning to defend the deposition of Mr. Dave Kuwiten as corporate representative for Select as ordered by the court?
I was.
Was Mr. Kuwiten present the morning of November 21st, 2025, prepared to have his deposition taken as ordered by this court?
He was.
Was
Your
Mr.
Honor, if I may just object again, I don't understand what this has to do with the reasonableness of these fees.
Objection's overruled, but let's keep it tight.
I have about 5 more questions, Your Honor. Was Mr. Kuwiten prevented from having his deposition taken that morning because he was apprehended by ICE agents?
That's correct. Yes, he was.
Prior to Mr. Kuwiten's deposition, how did you and Select's counsel communicate with Igor Zhu?
Only through Mr. Kuwiten.
Was that the only way that counsel for Select, you, were able to communicate with Igor Zhu?
Yes, we did not have any independent contact with Igor Zhu.
Were you able to communicate with Mr. Kuwiten after he was detained by ICE?
No.
Were you able to communicate with Mr. Zhu after Mr. Kuwiten was detained by ICE?
No.
Why not?
Because we weren't able to communicate with Mr. Kuwiten, and we only communicated with Mr. Zhu through Mr. Kuwiten.
Was Select prepared to make Mr. Zhu available for his deposition pursuant to this court's order prior to Mr. Kuwiten's apprehension by ICE at the Golden Lamb?
We were. I believe that Veteran had issued a notice to have Mr. Zhu's deposition taken on Monday, November 24th. We were coordinating and confirmed for that date, I believe. But on Thursday, November 20th, I believe counsel for Veteran reached out asking to reschedule that deposition instead of having it on the 24th. We had reached out to our client, Mr. Kuwiten, directly after that to talk about potential other dates for Mr. Zhu's deposition so that he could coordinate with Mr. Zhu. That was afternoon of Thursday, November 20th, but we never heard back from Mr. Kuwiten before he was apprehended by ICE the next morning, November 21st.
Was Select prevented from making Mr. Zhu available for deposition by Mr. Kuwiten's apprehension at the Golden Lamb that morning?
Yes.
Thank you, Mr. Lacy. I don't have any further questions.
Any questions for Mr. Lacy?
I do. Yes, please. Mr. Lacy, you testified that you were willing to make Mr. Zhu available for his deposition. Is that correct?
That's correct.
Are you familiar with the emails that were exchanged between counsel regarding the facilitation of Mr. Zhu's deposition?
I'm not sure exactly which emails you're referring to.
Any emails that have to do with the coordinating or setting up the deposition of Mr. Zhu as you previously testified?
I am. I was just referring to, in my testimony previously, I was referring to emails, I think the week of November 17th, in which the parties were attempting to coordinate the deposition of Mr. Zhu for November 24th, and then the proposed rescheduling of that deposition that arose on November 20th.
Do you recall emails from your co-counsel, Mr. Zalid, confirming that he would not produce Mr. Zhu as the court ordered?
I recall those emails, which I believe were sent after Mr. Kuwiten's detention.
Okay, but those emails occurred.
Yeah, I recall those emails.
Do you recall the contents of those emails?
Not precisely.
You would agree that Mr. Zalid refused to cooperate with the deposition of Mr. Zhu as ordered by the court.
Objection, Your Honor, unless you can see the emails. It calls for speculation.
Overruled. Answer if you can.
Could you repeat the question?
Do you recall an email from Mr. Zalid refusing to produce Mr. Zalid, or excuse me, refusing to produce Mr. Zhu as ordered by the court?
I recall an email from Mr. Zalid in which I think he said we would no longer be facilitating this deposition or something to that effect. And again, that was after Mr. Kuden's detention, at which time it became a practical impossibility for us to coordinate Mr. Zhu's deposition.
But you would agree with me that the email did not say we don't have contact with Mr. Zhu. The email was, we will not facilitate this deposition.
I don't recall the exact text of the email. I don't know whether it said we don't have contact with Mr. Zhu, but I agree with you that it said we won't be facilitating this deposition.
Okay. Would you agree that those emails were part of the exhibits filed in the motion for sanctions and the motions to show cause?
I believe they were.
Would
Yes.
you refer to those documents for the exact contents of those emails?
I'm sorry.
Would you refer to those documents to contain the exact content of those emails, these that we've been discussing here?
Yeah, I wouldn't have any reason to doubt
Okay.
the
So,
emails that were attached to the.
so if that email, if those emails and those briefs confirm that Mr. Zalid said we will not be facilitating this deposition, you would agree with that?
Sure.
No questions.
Anything else?
Thanks, Your Honor. One more. After Mr. Kuden was apprehended, was any counsel for Select able to facilitate the deposition of Igor Zhu?
No.
Thank you.
All right. Thank you, Ms. Lacy. You can step down.
Thank you.
Anything else?
Nothing, no other evidence, Your Honor.
Nothing from me, Your Honor.
Okay. Do I have everything that I need to know about this?
From us, Your Honor, yes. We would refer to the affidavit. Number 2 is our lodestar amount and the fees that we, or the costs that we receive.
Your Honor, yes, we will just, can I say a couple words at the podium?
Sure.
Thank you. We'll electronically submit the 2 exhibits, the deposition notice and the color-coded affidavit. As I said at the outset of this hearing, Your Honor, we believe the time period from November 12th through November 22nd should be reconsidered by the court respectfully, since during that time period we were cooperating and complying indeed with the order of the court to facilitate these depositions. We believe the court should consider the entries, all the entries, of course, Your Honor, but the ones we called out as not being necessary to accomplish what defense counsel sought to accomplish. We don't think they were necessary for the motions for sanctions or for the hearing. So we'd like the fees to be reduced by those amounts, and that they're color coded in the affidavit that we'll submit electronically, Your Honor.
Okay.
Thank you.
So, Mr. Lynch, you're also going to send me your exhibits
I
electronically?
can send those to you. I know I submitted the first one. We didn't refer to it, given the stipulation of the reasonableness of the rate. Would you like me to submit that as well?
You're talking about exhibit 1?
Correct, the OSBA study.
Okay, so you're withdrawing exhibit 1?
I was asking the court, given that my plan was to use that to establish the reasonableness of our rates, given the stipulation of counsel that the $250 an hour rate was a reasonable rate. I didn't see it necessary to do so.
So is that a yes?
Yes,
You're
I will
not
withdraw exhibit number 1.
Okay, so you're going to send me exhibit number 2 in electronic format,
Yes, Your Honor.
and Mr. Zlud, you're going to send me exhibits A and B
A and B.
in
Correct,
electronic
Your Honor.
format.
Electronic format.
Okay, and so we're embarking on a new era without a court reporter, so we're trying to work through our issues on this. So it's Jacob Lynch, Lentsch, and Eric Zalud, Eric with a C, Zalud, Nicholas Lacy, L-A-C-Y.
EY, Your Honor.
E-Y, okay, that's why we do these tests. All right, L-A-C-E-Y, right?
Correct for me, Your Honor.
Okay, well, we'll see if that helps. All right, yeah, just send me those exhibits. I'll take the matter under advisement, issue you a written decision.
Thank you, Your Honor.
Thank you, Your Honor. Appreciate it.
All right, I have before me a plea sheet. In this case, the defendant is going to plead no contest to the charge. Failure to report an accident under 662 90-day offense. Upon a successful no contest plea, count one would be dismissed.
That is correct, Your Honor. That's correct, Your Honor.
All right, very good. Need you up at the podium, young man. Raise your right hand. Please swear.
solemnly sworn to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
George Walker.
Sir, it is this court's understanding that you're going to plead no contest to the charge of failure to report an accident. That is a misdemeanor, punishable by up to 90 days in jail, $100 fine plus court costs. You understand that?
Yes.
You understand what a no contest plea is?
Yes, Your Honor.
All right. Two things about it I have to make sure that you understand. The first thing is that you need to understand that it means that you're not further desirous or wanting to contest this charge. You understand that? Yes?
Yes.
Okay.
Sorry.
The other thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes.
Basis for the no contest plea, Mr. Elm.
Potential civil liability, Your Honor.
Sir, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You had previously signed an advice of rights form. Is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
Your Honor.
Look at paragraph 5. You'll see a copy right there on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 25-11648. Any objections to the court having reviewed that report?
None from the people? No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you, between the time of sentencing and the time of my acceptance of your plea, if you commit misconduct as defined under the Michigan court rules, the court would not be bound by any sentence recommendation or evaluation. Do you understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people? No, Your Honor.
Have I complied with the court?
Yes, Your Honor. Yes, Your Honor.
Court will accept the defendant's plea to count two. Count one is dismissed. I don't know that there'll be a necessity to send the defendant over. I would proceed to sentencing immediately if you, but I understand there's an issue regarding restitution.
Yes, Your Honor. And we do have the victim here. We were prepared to do a restitution hearing if the court wanted to hear testimony on that matter.
I would. Have a seat, though.
And after that hearing, Your Honor, if you wanted to do immediate sentencing, we would have no objection.
All right, very good. Why don't we try to get it out of the way? All right,
We'll call Daniel Cope.
sir, please come forward. Be sworn.
Will you take a seat, raise your right hand, and do you solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Work class.
Daniel Cope.
It's COPD.
All right.
Thank you.
Good morning, sir. How are you doing? Sir, were you involved in a crash on June 13th of 2025? What vehicle were you driving? Was there any damage that that vehicle suffered as a result of that crash? And I'm showing defense counsel has been pre-marked as People's Proposed Exhibit 1. I believe this will be admitted via stipulation, but I don't want to. So I'd move to admit what pre-marked as People's Proposed Exhibit 1 by stipulation.
All right.
May I approach the witness?
When?
So, sir, I'm handing you what's been admitted now. Exhibit 1, I have a copy for the court as well, if the court would like. These are the photos that were in the report. Copy of them.
Yeah, okay. Got it.
Sir, this document in front of you, do you recognize these photographs? And do you recognize the vehicle in these photographs? Whose vehicle is that?
Mine.
All right. And so there's 3 photographs on this page, starting with the top left one. Can you describe what's in that photograph?
Sorry, Jen.
And it looks like there's some damage to that vehicle. Was any of that damage, or do you know what caused that damage?
The accident caused them.
Was any of that damage on the vehicle prior to the crash? All right. Going to the top right picture, what is that?
That is the left driver's side frame. The hole you see right there is where the crossmember, the left crossmember was connected to that hole right there to the frame. And you see, I don't know how good this picture is to you guys, but crossmember is supposed to go in that hole right there. But it got snapped off.
And how about the bottom left picture? What is that?
My driver's side, left side.
Okay. Now, the condition of your vehicle in these pictures, is this the same condition that it was prior to the crash, aside from the damage?
This,
Was there any work done in between the crash and when these pictures were taken, to your knowledge?
like,
In between the crash and when these photographs were taken, was there any work done on the vehicle?
yes.
What work was done on the vehicle between?
Someone happened to crash, right?
So the crash occurred, and at some point these photographs were taken.
Yeah.
Oh,
No way. I'm sorry.
okay. Do you remember when these photographs were taken?
The day of the accident would be June 13th.
Did you ever seek to get the damage repaired?
After that, yeah, I mean, I plan on getting it repaired after the accident occurred.
All right. What did you do in order to get the damages repaired? Who did you talk to?
Well, first I had to make a claim for my insurance company. And, the insurance takes a little while to do. So I had to, that's the free I can,
What was the
Why didn't the insurance cover all the damage?
Well, I mean, I did have full coverage, and so the estimate, they gave me, I mean, based on the prices and those are like auto body shops and like that wasn't generally covered. So I guess because it's 2007, they don't want to cover the whole expenses, Your Honor.
Because they really totaled it out and let you keep the vehicle.
Yeah, good.
Yeah, that's exactly what they did. Okay, go ahead.
Okay. Sir, did you ever take this to an auto shop for repair?
Yeah, I did.
Which auto shop?
It's what?
Does the name A2 Auto Group mean anything to you?
Yeah.
And when you went to that auto shop, was it for these damages or for something else? Did they ever provide you with any estimates or invoices related to these repairs?
Yes.
And what specifically did you have them try and repair, or did you ask them to repair?
Well, the first job, this is for my safety because it's my vehicle. I need to get the crossing. I was connected to the second picture on the top, on the right side. That's where the crossing was connected to. It was dangling there about 10 years. So I need to keep that for something else causing more severe damages.
I'm showing defense counsel has been marked as People's Proposed Exhibit 3. I apologize, I'm going a little bit out of order here. May I approach the witness?
Man,
Sir, I'm handing you from Marcus People's Proposed Exhibit 3. Can you please take a look at that document and let me know if you recognize it?
Yes, I do.
What is that document?
That was the first job I had to get done to my GMT there, the cross member job.
And this document, but what specifically is the document?
This is showing the receipts and the cash of the money that I had to pay to get it fixed.
And is this a fair and accurate copy of that invoice or receipt? People move to admit what's been marked as People's Proposed Exhibit number 3.
no, there. Exhibit 3,
I have a copy for the court. The court would like that as well. May I approach?
yes.
Thank you.
And so, sir, looking at this document on the right-hand side near the top, there's some columns that say labor and description, and then on the left-hand side it says part and description. What is that, or what was being serviced?
So the crossover needed to be the reversible crossover versus the piece was connected to the frame. That needed to be placed because it was basically broke off, snapped off.
And then where it says total and balance due, it says total I believe is 1,200 and balance due is 0. What does that mean?
So that means that's pretty much the power and labor for the job.
I guess what's the difference between those two lines? Do you know?
So still in the total 1,200. I don't think there is no difference, to be honest. It's just I think the mechanic wanted to just all shot itself together as one, what I'm saying?
Was there a problem with your cross member before this? Was there a problem with the support, their cross member before this? Accident.
When I got shipped a year prior before the accident, it was perfectly fine. It was, like I said, the truck came from a dealership saying I'm still paying for it. I mean, the truck was in mint condition. It was a nice truck, besides a little bit of rust. And it's pretty common for Michigan vehicles.
Fine, thank you. And so, sir, how much was paid out of pocket to replace that cross member?
Well,
I'm showing defense counsel's marks proposed exhibit number 6. May I approach the witness? Sir, here people proposed exhibit number 6. Do you recognize this document? And what is that?
that is the main receipt we received from the bottom again.
Is that a fair and accurate copy of that receipt for that invoice?
Yes, it is.
People argue that it was marked to propose exhibit 6 into evidence.
Any objection?
No, Your Honor.
Exhibit 6 submitted.
May I publish to the court?
Thank you.
And so, sir, who actually paid this $1,200?
Yeah, say.
Other than that cross member, what other repairs did you get done?
Yeah, well, the pictures right here from the first picture was the body needed to be done, and then the driver's side cab needed to be replaced.
Did you ever get an estimate for how much it would cost to get that done?
After calling around, that's right. Came to the conclusion of H2 Auto. He was the cheapest one, and the estimate was, well, was about $5,000.
How many different auto shops or dealerships did you speak to in order to get an estimate for these repairs?
Insurance, they two of them, they recommended for me to reach out to see how much they would charge, and they it was too out of my price range. It was too expensive.
Do you remember how much the estimate was for those two that your insurance recommended?
It was the first one, I think when I first reached out to the first one, they said it's going to take about over a month to repair the damages. You know what I'm saying? And I can't really tell you the bottom dollar how much I know it was not more than what we could manage.
So you got no written estimates from these other places?
No.
Go ahead.
I'm showing defense counsel's marks as proposed exhibit 2. May I approach the witness?
You may.
Sir, I'm handing you with the marks as people's proposed exhibit 2. Do you recognize this document?
Yes, I do.
What is it?
This is all the breakdown of what it took to replace the cab. Sarah.
And is this is it fair to say this is an estimate for that repair? And is this a fair and accurate copy of the estimate that you got from A2 Auto Group as it relates to these damages?
Sir.
People move to admit with some marks as people propose exhibit 2 into evidence.
No, Your Honor.
Exhibit made. Thank you. That's, yeah.
So, sir, looking at this, what was the estimate from A Auto Group for the repair to the cab and the body?
After I told him what the insurance was going to give me to cover the difference, he told me he would probably an additional $3,000 to do the job.
What was the quote from the dealership for how much it would cost to repair your vehicle's damage for the body, not the cross member, just the body?
Body. So his quote was 49.
Is that the 49.39.64 cents on page 2? Okay. And of that, how much did you say your insurance would cover?
The insurance, I believe they 19. Was it 1988?
So I've shown defense counsel's marks appeals proposed exhibit 4. May I approach the witness?
You may.
So I'm handing you what's been marked as people's proposed exhibit 4. Do you recognize that document?
Yes.
What is it?
So this is more of a better numbers, more of the facts. The insurance check was 1932 for my insurance.
But what is this document?
Yeah, sorry. This is the document showing what the insurance is gonna get, well, they was covering me for my truck.
And is this a fair and accurate copy of that letter from your insurance?
Yes.
People move to admit what's been marked as people's proposed exhibit 4 into evidence.
No objection.
No, Your Honor.
Exhibit 4 is admitted. But they paid that check to you, didn't they?
Yes, they did.
May I approach to publish the report?
Yes.
So, sir, the amount of that check that Progressive gave to you, is that the total payment amount on this document, that 1932?
Yes.
All right. And so when we take the estimate of the 4939.64 from, that would be People's too. How did that 1932 go towards the $4,900 estimate?
Yeah, so that's gig.
And so how much did you end up actually paying out of pocket for those repairs?
I think it's just a body job, not the cost of it was $3,000.
I'm showing defense counsel's marked People's proposed exhibit 5. If I may approach the witness.
May.
Sir, I'm handing you People's proposed exhibit 5. Do you recognize that document?
Yes, I do.
What is it?
This is the receipt the mechanic gave me for the job, for the cab job.
And is this a fair and accurate copy of that receipt for the repairs for the body damage? People move to admit what's been marked as People's proposed exhibit 5 into evidence.
Admitted.
Permission to publish?
Yes.
So, sir, you paid, or who paid the actual $3,000 on this receipt?
Yes.
So in total, that makes the total payments from your fiance how much?
With the cost number, it came to about 4,200.
Other than the A2 auto group and the 2 insurance recommended mechanics, was there anyone else that you spoke to about getting these repaired?
Oh, but I do, can I say this? I do know this much, that the ones they recommended was more money than what I'm at from this
Okay.
shop. Let me out of pocket.
So how much total are you requesting in restitution?
I just want, I guess, prepare.
I'm going to pass the witness at this time.
What are you considering fair?
So my truck, as of today, Your Honor, is fine. My truck is good. You know what I'm saying? So I'm happy with that, but it's a struggle with me and my fiance. We all have our struggles, It takes a lot out of our savings to do, fix my truck. So on behalf of her part, that's why I'm here today. I mean, if you ask my fiance, she wants the whole amount what she out of pocket back. But I'm not a greedy man, I just, that's why I come down to the conclusion.
What are you considering to be fair then, sir?
I'll be happy if I just, okay, so I missed 3 days of my job coming here, so, I mean, fair, I just say I ain't trying to get everybody, I mean, it's a struggle for everybody, Your Honor,
I understand that, but what are you considering fair? I'm trying to clarify the last answer you gave.
I think fair would be at least a body job, the 3,000 for the body.
Cross-examination.
Thank you, Your Honor. Good morning, sir.
Morning.
I'm going to remain seated here, so if there's anything you can't hear me say or don't understand, just let me know and I'll speak up and try to clarify myself, okay?
Okay.
So you testified that when you reached out to your insurance, technically they totaled your truck, correct?
They gave me the option to total it.
Okay. Versus getting it fixed?
Yeah, just the fact because I was still paying for this truck on my dealership.
Okay. And you said you have full coverage, correct?
Yes, sir.
So if you have full coverage, wouldn't that mean that your insurance would cover the rest of these repairs outside of your deductible?
In my opinion, from my experience, that's just insurance being insurance.
Okay, but you have $1,000 deductible on your insurance policy?
Yes.
Did you pay that $1,000?
I think that's what that's what they took away from the check they gave already. That's minus deductible.
So basically, they totaled your truck out for $2,932.19 and subtracted your deductible from it. Is that what you're saying?
I think in a way, I think so, yeah.
Okay, so they did.
Well, you think so. That's what they did, isn't it? They gave you the option to total it,
Yeah,
which means they would take the truck and pay you money,
yeah,
but they didn't do that.
yeah, because you know, in my opinion, my truck's worth more than what they was gonna
I
drive.
understand what your opinion might be, but I'm just trying to get a clarification on what your insurance company did. Insurance company did is they gave you the option. They paid what they would pay, which was basically $2,900. Took your deductible of $1,000. You got to keep the truck and whatever that was worth, and they gave you money.
I think so, yeah, yep.
Okay, go ahead, Mr.
Thank you, Your Honor. And sir, I want to make sure this accident happened on June 13th, 2025, correct?
Yes, sir.
Okay. And did you get any estimates before you reached out to your insurance?
No,
So how do you know how they came up with the number of what your truck was worth then?
honestly, I don't know how they came up with that number.
Okay. And you were shown a couple exhibits here. One was a document you provided from Progressive, correct?
Yes.
And that document is dated June 25th, 2025.
So are we looking at people?
The Progressive.
Okay. Oh, yes.
Yes, June 25th, yep.
Okay. And so this accident occurred on June 13th, 2025, correct? So 10 days later, you had essentially resolved this issue with your insurance, correct? And how many vehicles do you own that you drive?
Just the one, sir.
Just the one truck? And with a broken cross member, is the vehicle drivable?
It's not safe to drive, the broken cross member.
Okay. Yet you waited, and it looks like, and I don't have the exact exhibit number, but the date of the estimate for the cross member, that's dated July 12th, correct?
Yes.
So you waited after the insurance paid you out, you waited an additional 2 to 3 weeks to have your vehicle checked out.
The vehicle was closed.
Okay, but you didn't drive for 2 or 3 weeks?
That was a cross member.
Okay. But again, it sat there after you received the insurance check, correct?
Yes, sir.
Okay. And then even later, and I just want to find the date here, I believe it is July 17th, that's when you got the quote for the body repair. Correct?
July 17th.
It's I don't know the number, that might be the 4,900.
That's people's two.
Do you see that date on there, sir?
On the 49 page?
Yes, sir.
Oh, yeah, okay.
Okay. So July 17th is when you got that estimate, correct? Nearly a month after the accident and after insurance had paid you out on this, correct?
Yes, sir.
And you're saying you did not drive that truck that entire time?
No.
Okay. Why did you wait so long?
Oh, I mean, it was a job, you know, and we saved, we tried to get a house and it's not going on. And we just had to manage what was the insurance was going to cover and, you know.
And again, insurance had basically said this truck is not worth any more than the 2,900, right?
They did not say that. They did not say it's not worth that. They didn't give that option. They insurance. They don't want to truck.
And your insurance, similar to a medical provider, correct? They have repair shops that they choose to work with?
My insurance did, yes.
And you chose not to work with any of the shops that your insurance works with, correct?
Yes, correct. Based on the receipts, these numbers on the receipts would have been a lot more than, it is if I would have went through the insurance.
But if you, so you have full coverage, and if you would have chosen not to total your truck, your insurance would have covered the entire thing, correct?
But if that's one of the truck, I would have gotten it, like, put it in the truck.
But you did total the truck, that's why they sent you the check. That's why you didn't have to pay your deductible.
They gave me the truck to fix the damages based on what,
But you never paid that $1,000 deductible, did you?
They added that deductible to the 1,900.
Right, so they subtracted it from essentially 2,900, so you never actually paid them, correct?
Insurance?
Correct.
I never paid insurance.
Right, so if your insurance would have covered the repairs, how that works, and correct me if I'm wrong, but you pay that $1,000 and they cover the rest, that's the point of full coverage, correct?
For the $1,000 deductible, right?
Yes, you would pay the $1,000 of either to your insurance or to the repair shop as your portion of deductible. The insurance company would pay the repair shop the rest, correct?
Yeah, so with the 1,900, they gave me, yeah, like you were saying, that's with the 1,000 deductible. So it's like you said, it was like 29.
No, I think you're misunderstanding me, sir. If you had paid that deductible, your insurance company is Progressive, they would have paid A2 Auto Group or whichever auto group you had chosen to go through, correct?
They would have paid a little bit, they would have paid, the 19.
But you did choose to total your car.
No, yeah, I mean, I think it actually on it total.
Okay.
But I'm still, like I said, the truck's got a lot of life into it,
Oh, I understand that.
And for record, these trucks, based on facts, they go up to 500,000 miles. And my truck's only barely at 119. The truck has got a long life ahead of it.
Okay, and it's a 2007?
Yeah, but a lot of 2007 trucks are really nice. Inexpensive.
So what was your insurance company put a value on that vehicle, right?
The insurance,
They would have paid you a certain dollar amount, but taken the truck.
well, like, I mean, I feel like it wasn't justified for the insurance.
I'm not asking what you feel. What your insurance company said is we would give you 2,900 for the truck. That's really what they said to you.
Instead of giving me the check, right?
Well, they would have given you 2,900 and taken the truck, right?
I believe so.
Okay. And so what they did, and they gave you the other option that they gave you was, okay, you're going to keep the truck. You need to pay your deductible. We'll give you the balance. And that's where the 1,900 somehow comes from, right? So at the time of the accident, your insurance company had valued that truck at $2,900, basically $3,000, $2,900.
Yeah, to the insurance, selected, yes.
That's what they valued the truck. Okay. You don't have any further questions, do you?
No, you're all right.
Good. Any redirect?
No, Your Honor, thank you.
Thank you. You may step down.
Your Honor, people have no additional witnesses.
Any witnesses for the defense?
No, you're.
Okay.
Any argument?
Your Honor, I think the court's heard all the testimony. I believe the witness said he'd be asking for $3,000. I would ask the court order $3,000 restitution for the damage that the victim has shown through the receipts. Thank you.
Your Honor, I believe that damage should be capped at $1,000, which is the amount that this individual's out for the cost of his deductible. I find a lot of things in this case interesting. The fact that he did take the payout prior to even getting estimates to fix the work. He chose to not go through repair shops that would have been potentially fully covered by the insurance. That's the point of having insurance. I think And I think there's almost a double dip at the apple here where he's received the insurance payout. And now is asking my client to cover the work that if his truck was worth it, his insurance would have covered. And so I think what he is realistically out based on the actions of my client is that $1,000 deductible that was deducted from $2,900 $32.19 amount when he was sent the check for $1932.90.
We're just gonna take a brief recess. I'll come back to a decision on it as well as sentencing.
Thank you, Dr. Paul. Rise.
Well,
Yeah, what?
they said you can't move.
What?
You were the other side of the accident. My husband was.
That's the guy that Oliver.
Cakish or the other one? This guy I just called for sentencing?
Cash.
Yeah.
Why, did you want to step up?
They just said they were here. They didn't tell me they wanted to talk.
Yeah, we didn't know that we were supposed to call to get restitution and stuff or anything like.
Hang on,
Bring him
go
back.
get them. Yeah, you should have stepped forward on it. I didn't know you were here.
Been in court, so
Yeah,
understand.
This is our first time ever. Well,
All right. Come on up to this podium over here.
okay, if I come with him.
Yeah, I don't care.
This was, help me speak.
Yeah, I'm sorry. I didn't know the victim was here. People against Saliba George Kakish, 260-149-962. I have Mr. Clovis. I'm sorry. I didn't know Mr. Kakish, the victims were. Why don't you go right over to the microphone over there, sir? And
there's a microphone right on that rail there.
and state your name, please. You're good. Just relax. You can go in there if you want. What is your name? Gotta go.
Roy, please.
Humphreyes.
If you want to use RE like us.
Okay. And what is your name, ma'am?
Sarah Humphreys.
Okay. You two are married? He was the only one in the car, right? So you just heard what I ordered the sentencing. I'm sorry. I did not know you were there. I usually call out the name, but I just thought there was no restitution. So go ahead. What would you like to tell us?
I say, Your Honor, just, the pre-sentence report didn't have any reply, that's why I relied on.
Right. I got it. What would you like to tell me?
Well, I was actually leaving work at 12 o'clock. Every time I take Dick's to King Road, my light was green. Give that turn, went that on the green light, turned my right, get down to there tonight before from the police station. This is 5 minutes, I got off the phone with the wife and I got smacked. Right from the police station on King Road.
Did you have any out-of-pocket expense here that wasn't covered by insurance?
Yes.
What?
He had,
Wait, I gotta have him talk though. I mean, I'll let you stay there.
Paid out of pocket of $2,000 for the $2,000 deductible for the truck.
Okay, now wait a minute. You had insurance though, right?
Yeah.
You gotta make the insurance claim. Didn't you make an insurance claim?
Yeah.
So then they paid for it, right?
The other half they did, but I paid the $2,000.
Okay, so keep your voice up nice and loud for me. You had a $2,000 deductible?
Yeah.
I never heard of,
Do you have some paperwork that proves that to me? Let me see what you have.
Very good.
Okay, come on up. Yeah, that'd be great.
oh, you're welcome.
One for that now.
well, last year, all those.
Yeah, just walk with them all, help here.
It's the rest.
Thank you. Wow, it sure looks like it.
What insurance company is it?
I'm just saying, based on this report from Vitality Collision Repair, the total bill, and I'll invite you to look at this, was $44.17. The deductible they have insurance is $2,000, and the net total is $24.17.73 that's due from insurance, and then he was to pay $2,000, looks like. I'll be glad to share that with you. John, would you hand that to him, please? Now, I want to know if you have, you might want to consult with a lawyer about some of these injuries and some of this other stuff like wage loss. Okay?
That's the first part of it.
Right. Right. Well, I either have to order that 2,000 or you can tell me you want an adjournment to be more,
Honestly, I can just talk my question.
yeah, go ahead. So do you understand what I'm saying, Mr. Humphreys?
I'm not quite, no.
Well, when you're involved in an auto accident and you have insurance, which you did, you're entitled to, like I see, looking at this letter here saying you missed some days of work. If you weren't paid, you can go to your own insurance carrier and make a claim for 85% of your pay. So you might want to talk to a lawyer about some of this before you go on too far.
And it's that 85% is tax free.
Right.
Oh, wage loss.
But if you were paid, that's different. But I'm just telling you, you might want to talk to a lawyer. Are you satisfied with this?
We're satisfied if we may have a little time to pay. them.
Yeah, restitution, I'm gonna order of $2,000, sir. I'm sorry. That's $31.75. And I am really sorry I didn't have I didn't call you up here early. I am really sorry about that. My apologies. So restitution be paid through the court to Roy Humphreys, and he is the victim. So he's going to pay his fines and costs today, and then tell me when he can pay the restitution, if you would. And you ended up paying that 2,000, right? Okay,
May 15th, Your Honor, you had given that.
that's fine. You can pay by May 15th, sir?
Yes.
In full?
Yes, sir.
Okay, go ahead. So you're gonna pay fines and costs now, Heather. So he's gonna pay $11.75 today and the balance by May the 15th. I really wish you well. Did you want to say anything else?
I don't have anything online.
You can talk to a lawyer. You should talk to a lawyer. Do you guys understand what I'm saying?
We called,
I don't want to know what they said if you talk to them.
no, I called my.
I don't need to know who you talk to. I just want to make sure that you know you should probably talk to a lawyer, and I'm gonna hand back everything else that you handed to me, okay? So one of you can come over here and get this again. And I again apologize sincerely to you for not calling you up here earlier. I'm not gonna change my sentence though, in fairness. Be careful, will you please? Thank you. Anything else, Mr. Clovis?
Watch those lawyers for photos.
Thanks a lot. Have a good day. Take care.
Thank you. Take care.
And I know you have one. You were being facetious. See ya. Eugene Neely, Jacob Eugene Dwayne J. E. Neely, 25B148494A. Mr. D. Neely, what's going on?
All right, Judge, I apologize. My client travels for work once a month.
Yeah, give me that. He can leave the state for,
Leave the state. for that.
I'm gonna put that right on the order. Can leave state for employment purposes without consent.
Okay. Thank you, Judge.
Okay, I'll add that right to the bottom. Can leave state for employment without consent. So you just need to have proof that you're driving out of, when you're driving out of state for employment purposes, okay? All right, thanks a lot.
Thank you, Mario.
Bye.
Judge.
All right. Mr. McNally, I'm sorry, your name.
Jacob Eugene Kalanji.
You were placed on probation. This was a visiting judge, 9 months. You still owe money. You didn't show up for your show cause on September the 4th. Charges, you failed to pay your fines and costs is ordered, balance owing 305. That is the charge. I understand you probably have paid it down since then. But if you plead guilty to that, your probation could be revoked. You could be incarcerated for up to 90 days here. Do you understand that?
Yes.
Did you sign an advice or rights form today or not?
No.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're going to be giving up all the rights. We will not have a hearing. You understand that?
Yes.
To the charge. Okay, and you have the right to a lawyer. You understand that?
Yes.
Do you want a lawyer? You have the money to pay this.
Yeah. Continue.
Hang on. How much does he owe, Heather?
He has a balance of 180 on this case.
Do you have that money?
Not only have to pay today.
Where are you working?
Make beats.
Where?
I make beats for record labels.
Where you gotta go to get the money?
They use the wire, it's not coming.
I'll tell you what. How much did they charge him, the visiting judge? He paid about $380 or something, didn't he? Why'd you play with this like this?
I was
Did you charge him?
The total fines and costs for this case was 520, Judge.
Do I have a review hearing date on his 771 status?
It was today.
How long will it take you to get the money? No, you said today you were gonna pay it, right?
Yeah, he's gonna give me time. I got another course I pay today.
Because his probation end date on this case is April 2nd.
The prosecutor.
Oh.
We don't have a phone that's working, Bill.
They fixed it.
Did they?
I'll explain later.
Mr. Beaton,
Yes.
when you gonna grow up? You seem like a nice, gonna grow up.
I'm
Come on in here. Mr. Beanie is here for a review hearing. It's false information. I wasn't here. I wouldn't have charged this much. He still owes 180. He's paid, would you say again, Heather?
He has a balance of 180 left.
Yeah, I know, but how much did he pay on this? Looks like he paid 325. Right?
Sorry, Judge, I'm pulling up the financial
name?
report.
Caitlin Foley, Fire, Boston Township.
How much did you pay on this?
Oh, I'm not sure.
340 he's paid, Judge, total.
I wouldn't have charged this. It's false information. He seems like a nice kid. I don't know why he's acting like a criminal, but you want to just move to dismiss this? I'm willing to waive the balance of the fines. Would you send in a stip for me? Mr. McGee-Neely,
Yes.
grow up. You're 23?
2.
Melissa Kennard, who is a victim advocate for the Warren County Prosecutor's Office?
Correct, sir. Yes, I do.
Okay. And this vehicle that was in question, are you aware it was a 2025 Mazda rented to Mr. Howard back in July of 2025?
Correct, sir. I do have the rental agreement with me also.
Okay. And are you aware, was the vehicle recovered in this case?
I can pull that up right now just to get more of an accurate answer.
Yes, the vehicle was recovered.
Okay.
There's no dispute on that.
All right, and we're
Yes, sir.
talking about September 9th of 2025, and restitution request was made by Avis, is that correct?
Correct, sir.
All right. Within the document that was sent, do you have a copy of that in front of you? It was sent dated December 11th, 2025.
Yes, sir, I do.
All right. I note that there were some rates that were included in the document, daily, weekly, monthly, and then a request for the amount of time that Avis did not have the vehicle back. Is that correct?
Correct, yes.
And we were talking about a
Oh,
period.
I apologize for interrupting, Mr. Harris. Mr. Moss, that part's not in dispute, right?
No, Your Honor, we're not disputing the weeks or the months, the rental fees.
So we're talking about the investigative fees, the impound tow fee, the certified letter fee, and the
Yes.
administrative fee.
Administrative fee. And also to rent a car, you have to pay money, and he paid $450. It's not reflected on this, and it just happens to equal the investigative fee. So that's really our problem. We're about $810 off. So if they want to just.
All right.
if that-
Well,
if that
Sir,
works
sir,
for them.
hold it. Sir, do you show that he paid a deposit?
On the rent, so on the rental agreement, it does not include the deposit, includes the estimated charges for the rental of the duration of that rental. And how it goes is once the vehicle is returned, on time per the agreement, the deposit is refunded back. It's not a processed payment. It's not a process. It's a processing payment. So it's not a final charge. However, in this case, because it was extended to multiple days, so it includes in that charge whatever, and then whatever is due has to be paid also.
So he paid $450 at the time he got the car, right?
Per the rental agreement here, it says his charges were $427. Depending at the deposit will go between $200 to $450, depending on the card, or if it's a debit card or a credit card. So that will be the amount range of the deposit at that time, sir.
Okay, go ahead, Mr. Harris.
What became of that deposit?
So if the contract was returned on time, it goes back to the original payment. However, in this case, because there is extension and the vehicle has not returned and everything, so it goes into the balance, and then whatever is remaining has to be paid also.
Was that included on this restitution request? I noted a $450 recovery fee. Is that part of the contract, or is that?
No, sir.
Okay. So in a normal case, if the vehicle was returned on time, that would have been returned to the renter?
Correct. Then the final charges will be whatever was estimated or quoted at renting the vehicle or booking the vehicle.
Okay, to your knowledge, was that ever refunded to the renter?
To my knowledge, I would not know, sir. No.
Okay. There are three things in dispute, a recovery investigative fee, which is on this. What is that for?
The recovery investigative fee is the fee that we do charge for recovering and investigating. So whether it's identifying where the vehicle is, sending recovery so we can ensure that we are getting the proper information on where the vehicle is and located. So that is part of that charge, sir.
And do you have to send an individual go retrieve the vehicle?
To my knowledge, as per, because it's a different department, I wouldn't 100% know the processing of it. But yes, so every time there is an investigation requiring a vehicle that has not been recovered or has been rented overdue, we do have to start an investigation to find that vehicle, and then before dispensing the impound or the tow or the repo.
Okay, so employees of the agency are involved in that and would have to go recover the vehicle. Is that fair to say?
Yes, it goes into our loss prevention department, which they handle all the investigating on all the recovering and all of that, sir.
All right, there's also a certified letter fee. What does that involve?
So that is whenever we are sending a letter of demand or any letters to the renter, so that we ensure that it's sent to them. We do have it certified mail. That way we ensure it's received by them and someone is signing for them, or it's received to the correct address that we have on file.
Okay, so there is an expense to Avis to do that, correct?
Yes, when it's a certified letter, correct, yes.
All right, and then also there's an administrative. What does that involve?
That will be for the administrative personnel and conducting all of that. So if they're assigning, whether it's doing the certified letter or assigning if we need to impound it to process. So all the administrative people will, that is the fee for it, sir.
Okay, and these are all expenses that wouldn't have been incurred had the vehicle been returned on time, correct?
Correct.
All right.
Mr. Moss, is the impound towing fee in dispute?
No.
Okay.
This, as you had said, this letter, and I've marked it as State's Exhibit 1, is that kept in the ordinary course of business with Avis?
It will be with our loss prevention department. As you can see in the bottom of the email, there is a Virginia Beach address, and that is where our loss prevention department is located.
No objection to Exhibit 1, right, Mr. Moss? All right, Exhibit 1 will be admitted.
All right, no further questions at this time.
Mr. Moss, do you have any questions?
Yes, the rates that you quoted, the rental rates, those are your normal retail rental rates, correct?
Well, the rates are dependent on the days of rental. So if he is quoted a rate between this time and this time, of course, the rate changes from day to day depending on demand. So for that instance, on that particular days, this is what the going rate was for.
While the car was gone, right?
Correct.
Okay. And as you, just to be clear, the employees are full-time employees that would go out and get the car, right?
As I said, because it's a different department, I cannot say for like a surety that someone will physically go out because I do not work for that department. But these are the investigative fees that they require to do their full investigative needs and everything to recover the vehicle.
Okay, I have no other questions.
Anything else for this witness?
No, Your Honor.
All right, thank you, sir. This concludes your testimony in the case. You're also designated as the victim representative, so if there's anything you want to tell me before I impose a sentence, I will listen.
No, Your Honor.
All right, do you want to remain on the Zoom for our hearing, or are you done?
If I am not needed, I would, because I'm the only manager available on duty, I would, if I'm not needed.
I don't need you anymore, but if you want to stay, you can.
Okay, I appreciate that, sir. Thank you very much.
Okay, so are you logging off, or are you?
Yes, sir. I will be logging off. Yes, sir.
Okay, all right, thank you, sir.
Thank you very much.
Anything else on the issue of restitution, Mr. Harris?
No, Your Honor.
Mr. Moss?
Your Honor, we conceded that the rental revenue is owed, and that's the retail revenue, which would cover the admin costs and overhead costs that they're billing separately. There's no evidence that these are losses, the admin or recovery fee. The certified letter fee, certified mail costs about $10. So that's an inflated number as well. So yeah, he's wrong. He kept the car, and they're out that revenue. But I would ask the court to reduce the total number by the 450, the 300, and the 60. And he did pay a deposit, and it's not reflected in here. He paid $427. We would like it. He never got that back, which they had every right to keep because he didn't bring the car back. But if we're going to be accurate on this, it should be reduced by that as well.
All right. So are we going forward in the other case with an arraignment and a plea and sentencing today?
Yes, that's my understanding.
Okay. All right. So let's go ahead and do that, and then we will do the sentencing for both of the cases together. I know, Mr. Howard, we went through this not too long ago, but We need to go through it in each of the cases. First of all, with regard to the arraignment, you are charged with 1 count of aggravated possession of drugs. This is a 5th-degree felony. It's punishable by up to 12 months in prison and a $2,500 fine. There is automatically a waiting period that goes into effect after an arraignment, which is designed to give you time to think about what you are doing before we go forward. But Mr. Moss tells me that you want to waive that waiting period and you want to go forward with a plea and a sentence today. Is that right?
I do, Your Honor, yes.
All right. How old are you?
43 years old.
How far did you go in school?
Some college.
Are you able to read and write English?
I am, Your Honor.
Are you under the influence of drugs or alcohol?
No, I'm not, Your Honor.
Are you taking any medications?
No, sir, Your Honor.
Are you a United States citizen?
Yes, I am, Your Honor.
If you enter a plea of guilty to this charge, I'm going to put you on probation. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir, Your Honor, they haven't.
I have a document entitled Change of Plea and Entry. It looks like on the second page there is a signature above the line defendant. Is that your signature?
Yes, it is, Your Honor.
Did you review this with Mr. Moss before you signed it?
I did.
Are you satisfied with the representation that you've received in the case?
All very satisfied.
You're going to enter a plea of guilty to 1 count of aggravated possession of drugs, 5th-degree felony, punishable by up to 12 months in prison, $2,500 fine. If I do send you to prison because you violate the terms of your supervision, the maximum penalty also includes an optional period of post-release control of up to 2 years. Your rights really haven't changed that much since we went over them a few months ago. Still have the right to make the state of Ohio prove that you're guilty of this unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
I do, Your Honor.
Mr. Harris, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about September 9th of 2025 in the city of Lebanon, Warren County, Ohio, the defendant Christopher Howard possessed methamphetamine. It was lab confirmed at 0.97 grams.
Hang on those facts, Mr. Moss.
No, Your Honor.
Mr. Howard, did you hear those facts?
I did, Your Honor.
Do you admit they are true?
They were in the car, yes.
You understand the right you're giving up by entering a plea?
I do.
Which plea?
I plead guilty, Your Honor.
Based upon the plea of guilty, I'm going to find you guilty. I think that you have made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. We have 121 days of jail time credit. Is that right?
That's correct, Your Honor.
All right. Mr. Harris, on behalf of the state.
Your Honor, on the matter of which he was just arraigned, I do have an arraignment entry, so we'll put on there reflecting what OR bond and have Mr. Moss signed off on that.
Sure.
We'll get that filed. There is a reimbursement request in that the drugs were sent to Miami Valley. There's a $250 reimbursement fee that would be to the Lebanon Police Department. Obviously, 0 days jail time credit. Any jail time credit would go to the other matter.
I mean, we're doing sentencing in both of these. So is there anything else you want to tell me in the 18 case?
We're talking about the restitution. Yes. Your Honor, on that, obviously the defendant, for whatever reason, kept this vehicle 6 weeks beyond what he agreed to. I think he had rented it for 3 days. I think all these charges are legitimate. As far as any type of recovery and administrative fees, this is extra work that they would have to do to recover the vehicle. Again, Mr. He indicated that this involved out-of-state employees trying to recover this vehicle. There was, for certified letters, obviously a cost to the agency, to Avis budget. We would ask that the entire amount of the restitution as requested would be ordered as an order of the court, that being $5,042.72.
Mr. Smith, anything from probation?
Nothing further, Your Honor.
Mr. Moss?
Your Honor, the original plan was to finish the case and then he goes back to Fayette County, but the new charge complicates that. So we would ask for community control on both cases with or I guess the court could impose time served on the motor vehicle case. And then he's gonna go to Fayette County and resolve that. On the restitution, I've already discussed that. We want, he's asking for credit for what he paid. And also, if they're employees, that's part of their overhead, and then charge the company separately. They have a loss prevention department. That's what they do. And that's paid for by the retail fees that he's agreed to. He will pay in restitution.
Mr. Howard, anything that you would like to tell me?
I would, Your Honor. It's been a long time since September 9th. And I rented this car I had moved out of my mom's because there was some stuff going on. And I rented this car because my car was in the shop. It broke down on 275. And at that time, I was living in my car. And when it broke down, my first note was, what do I do? And I was fighting with my my warranty company to fix my car. And I just didn't. They kept it longer and longer. And I know I was wrong. And I just I played it too long, you know, and I regret it because this has been going on since September 9th. I've been here, I've been in Fayette County, and then I get out of there and I'm charged with the same thing in Kentucky that I'm here with Avis. So I'm just ready to get my life back together. I got out last week in Kentucky and I got a job already. I start today and I just want to get back on with my life. I apologize for holding up to the court.
What's the status of your case in Fayette County, and what kind of case is it?
I'm on OR bond. It's a possession charge, sir, from January of 25.
All right. Court's going to put you into my community control program. I'm going to do that for a period of 3 years. I don't want to put a lot of effort into you, Mr. Howard. So if you're being supervised on felony probation in Fayette County, we will transfer your supervision to Fayette County. I do think it makes sense for you to engage in drug and alcohol treatment. Pay this restitution. I'm going to set restitution in the amount of $4,242.72. That is what is on the exhibit, less the administrative fee, less the recovery investigative fee, and I gave them $10 for a certified letter. You are entitled to credit for the $450 if you paid it. So the restitution figure is $4,242.72. Just make sure that you give proof to Officer Smith that you paid that $450, and she'll credit that against your restitution. The rest of it you owe. And as soon as you pay the restitution off, I will either convert you to non-reporting probation or transfer your supervision. But we're going to keep a close eye on this case until that restitution is paid. I'm not going to impose a fine. I am going to impose the costs. I'm going to impose the $250 in reimbursements on the drug case, but I want to make sure that the restitution gets paid first. I'm going to give you 121 days of jail time credit. If you violate the terms of your supervision or you leave the state without permission, I can send you up to the maximum penalty in each of these cases, which is 12 months in prison for each of them, plus the optional period of post-release control of up to 2 years. Is there anything else we need to do? Anything I forgot?
No, yeah.
Let's go ahead and flag this for review in September. So if it's not paid by September, I want to set this for a status conference so that we can figure out what's going on.
Okay.
Okay? All right. Finally, Mr. Howard, you do have the right to appeal all of this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they'll all be provided to you at no charge. Good luck to you.
Thank you, sir.
The State of Ohio versus Andrew Jones. This is case number 25 CR 43113. Did we already do a hard restart? Yes. Present before the court is Mr. Jones, represented by Mr. McKenna. We have Mr. Harris from the prosecutor's office and Officer Evans from probation. We're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor. Yes, Your Honor.
Is there any reason not to go forward with sentence today?
No, Your Honor.
We have 3 days of jail time credit, no restitution, right?
That's correct.
All right, Mr. Harris, on behalf of the state.
Nothing further to add at this time.
Officer Evans?
Yes, Your Honor. I do believe that Mr. Jones would be a good fit for this court's REACT program. Additionally, ordering drug and alcohol treatment, as well as completion of Thinking for a Change and random drug testing.
Mr. McKenna?
We agree with that, Judge.
Mr. Jones, anything you want to tell me?
I hate that this happened, and I'm very sorry about all this. And I have been in treatment before this. I got in trouble before I got the DUI and drug charges and everything. I had previously already entered myself into drug treatment. I've still been there to this day. I still go once a month.
All right, court's going to put you into my community control program. That's going to be for a period of 3 years. I'm going to put you in the REACT program, so that will give us a little more support in the case. You and Officer Evans are going to get to know each other and figure out if you need any more drug or alcohol treatment, or if we just need to do some sort of maintenance for your sober support. So we'll figure that part out. I do want to have you complete the Courts Thinking for a Change program. I'm going to give you credit for the 3 days that you have already done. I'm not going to impose a fine. I am going to impose the costs. If you violate the terms of your supervision or you leave the state without permission, I could sentence you to up to the maximum penalty in this case, which is 12 months in prison. Anything else we need to do? Anything I forgot?
Yeah.
No, you're.
All right, finally, you do have the right to appeal this to the 12th District Court of Appeals in Middletown if you don't have the funds to hire a lawyer to obtain it.
And Your Honor, Robert Ellman with it on behalf of Mr. Walker, who's coaching. Mr. Walker, can you please state your name for the record? George Walker.
All right, I'll make a determination on the restitution during sentencing. Is there anything that you wish to say before I do impose sentence on this case?
Your Honor, just that Mr. Walker is a young man who made a mistake here. He's here taking accountability for his actions and wishes to move forward from this in the most positive way that he can.
Anything you want to say, sir?
Yes, Your Honor. I am just like my public defender said, I am a good young man, and if I felt liable for these charges, I would have paid them all without question. Just talking about. Yeah, other than that, I'm just grateful to have you as my. Thank you.
All right, in this case, just send to the court, I'll order fines and costs the amount of $350. I will also spend 90 days in jail with reference to the restitution. And it sometimes can get complicated with automobile crashes. Certain limitation when somebody doesn't have insurance as to what they can collect, or if they had PLPD, what they can collect. In this case, it even gets more complicated in a sense, because, and I'm going to give a couple scenarios in terms of assessing the damage. First of all, the individual will be entitled to the restitution for their loss. They are to be made whole. That doesn't mean that they can get a new vehicle. And so those would be sort of the extremes in terms of looking at it. In this case, what the victim chose to do is causes maybe for them a certain problem with the restitution. The only value I know for this vehicle is what Progressive valued the vehicle. That is $2,932.19 is what they valued that vehicle. Now, it may have had a greater value, and I'll explain that, but that's the only value that's before that I have. He could have chosen, and the insurance company gave him an option. He could have taken the $29,32.19. The insurance company would have taken as scrap, in essence, the truck, and then theoretically everybody's done. In theory. But had he done that and then shown that the vehicle was actually worth more, but the insurance company wasn't going to pay him more, he might have been entitled to restitution for what that actual value was. But I don't have that before me. What he elected to do instead was, and he was very honest and I appreciated his testimony, what he elected to do instead was, I won't take the payout. I will, in essence, keep my vehicle, pay my deductible, and get the back balance or get the excess amount. So if you follow the math here and the calculation here, what really ends up happening is he's paying $1,000 for that truck is really what's happening. And so he's whole in that regard in a lot of ways, because if he had done it the other way, what would have happened is he would have taken the 2,900, I'll just call 3,000. He would have taken the 3,000. They would have taken the truck. He would have said the truck is worth more, and then he would have come after him for what that amount was. That's how he would have been made whole. But he's been made whole because he has the vehicle. But that doesn't mean he again gets to take that vehicle back to what he says the condition was. Because in theory, that's not part of his loss. I don't think. And so he made a decision. Now, why would somebody make that decision? I understand why he made the decision. And again, why I appreciate his testimony. He made that decision because had he taken the 3,000, he would have gotten the 3,000. They would have taken the truck and he would have actually never seen the 3,000. Why would he have never seen the 3,000? Because there's a lien holder. They would have paid it over to the lien holder and he'd still have to pay on this truck that he no longer has. I get why he made the decision that he made, but that doesn't mean that he has a loss that this defendant is responsible for. He made his financial decision and he has his truck, which he says has that value of going up to 500,000 miles. Again, most people know I'm a Ford guy. That's a Chevy. Yeah, I don't know. But anyway, I say that facetiously. But I'm just saying there is no loss. The $1,000, he paid $1,000 for the truck is what he did. Bottom line. And then he got the extra money. He could put that toward repairs. He could have put that toward anything he wanted. So for those reasons, and based upon what's before the court, I am not going to order restitution of it. When can you pay the fines and costs of $350?
Your Honor, can we have a couple of weeks, please?
Pay it by April 15th.
Gotcha.
Thank you.
Thank you very much, Your Honor.
Thank you.
Appreciate you. Just have some.
Are we ready? Are we ready to roll? We're good to go. Prosecutors in.
You're fine.
Let's do this. Court does call the case of the people versus Michael John Clark II. Do I have a DV call?
Yes, I just put it in here.
Just half a step forward. Right there.
Woods?
Tiffany Woods for the people.
All right, there she is. All right.
Good morning, Your Honor. Joe Simon on behalf of Mr. Clark. State your name, Michael.
Your Honor, my name is Michael John Clark II.
All right. He's here for purposes of arraignment on a stalking case.
Wait, formal reading, Your Honor. Stand mute.
and in every way, form, or reading standing near the court will enter a not guilty plea on his behalf. This is mine. I will set a retrial in this case for April 6th, 2026, 9 a.m. As to,
I don't know if the people want to go first.
people have a request on bond.
Judge, I'm just pulling up the case. I need one moment.
All right. I don't. For a moment.
Your Honor, before she speaks at the bond, this is a case that's going to be before Your Honor. Is it possible to schedule that at 10 o'clock instead of 9? I have to be in Chelsea at the same time. That would work out perfectly.
You things benefit him. Yes, I'll set it at 1 p.m.
I should be quiet. Ms. Woods?
Yes, Judge, are you ready?
Oh, yeah, I'm ready.
So, Judge, we'd asked for no contact with Peyton Lee Trelfa, and we're also asking for a GPS tether hot zone. The address would be 244 Oak Lawn Avenue in Ypsilanti. So I guess what happened here, Judge, was the defendant and victim in this matter work with one another and previously dated. The victim ended the relationship and the defendant repeatedly followed her at work. On one occasion when she was leaving work and walking to her car, the defendant chased her in the parking lot on foot while she was attempting to go to her car. On another occasion, she was attempting to talk with the victim. Then the victim told defendant that she did not wish to talk with him. And then she also texted her supervisor telling him that the defendant would not leave her alone. And then at some other points, he would stand outside of her vehicle. He would continue to follow her. He not only with the text messages, he was sending her gifts at her home address. He also left her a beverage at her locker and work. So we're asking for no contact with the victim based on those allegations. Judge, we would also ask for all standard bond conditions, including no assaultive behavior, no stalking behavior, no firearms, ammo, components, or weapons. Do not possess or use any devices for creating gun components. No alcohol, drugs, marijuana, and not to leave the state.
What was the address you gave me that you did wanted to no go?
244 Oak Lawn Avenue in Ypsilanti.
Said Oak Lawn?
That's correct, Judge. I will spell it to you. It's OAKLAWN.
And there would not be a need for the 1200 State Circle, or is there a need for a no-go to that address also?
Let me see. Is that the work address? Let me look real quick.
It's the stated address in the complaint.
Your Honor, I do have information on that one. It's my turn.
Will it clarify?
It should.
I believe the 244 Oak Lawn Avenue is the address where the victim lives.
Yes. The 1200. Mr. Simon, do you know what that is?
I do. That is in fact the work address. It's Huron Valley Ambulance. My
Huron Valley Ambulance.
Yes. And, you want me to continue? I'll wait till it's.
Are they both still working there?
That's what I wanted to clarify. They are, Your Honor, but They are and they aren't. So I know you're going to roll your eyes at that statement, but my client, this matter was investigated internally there. My client is technically on administrative leave. The investigation there is concluded. The only reason he's not fully reinstated at work is because of this pending matter, and they want to see how it resolves. But here's how HVA handled the matter. My client is has to be there present 1 day a week. To his continuing education is there, but he arrives at a time that is a completely different shift, separated by like 3 hours from the shift of Ms. I don't know how to say her last name, Tralfa. She is on a night shift, gets off at 5 a.m. On Wednesdays when he goes to his continuing education at 8 a.m. That would be the only time he is on that campus is on Wednesdays at 8 a.m. And he does want to be able to continue because otherwise he will lose his employment. And so he has no problem at all with a no contact. He not only will not go to the address in Ypsilanti, but he lives in Hillsdale. They have quite a geographic distance between them.
I guess with that explanation, what happens if her shift changes?
Then he's going to have to not be around to comply with his bond conditions.
Right. I get that. But does HVA then switch his shift or what?
Well, just tell me.
We have a shift that changes every 6 months until for another 3 months, but we have our 8 months. And they've already set up my work shift being on different days.
Right. Your Honor, he's saying that the rotations in schedule don't happen for a number of months, and the first review is 3 months out.
Yes.
So the earliest there could be a change would be that.
3 months from now. All right. Okay. Anything else you want to say, Mr.?
Yes, Your Honor, I do request a personal bond. My client's a lifelong resident of the state of Michigan. He owns a home in Hillsdale. I've explained the employment situation. I did tell him there was a possibility of a GPS tether just because of the nature of the charges. I can tell Your Honor that I don't have the complaint in front of me. I don't know if it lists a date range, but I can confirm from what I understand that there is a cessation of all contact a date in February, that there hasn't been any contact, there won't be any future contact. My client will abide by any court order to refrain from contact with the complainant, and if the court imposes a tether, he's prepared to walk right over to community corrections today. I alerted him that was always a possibility, and he's not a drug user or alcohol user, so he'll abide by those conditions as well.
Court will set the defendant's bond at $25,000 personal cognizance. I will order all standard, including no assault behavior, which I'll go through specifically, no possession of any weapons, firearms, ammunition. There is also to be no possession of any alcohol, recreational marijuana, or any illegal drug. Do you understand that, sir?
Yes, Your Honor.
Hesitated. You understand what I
I
just?
think he wanted.
I was reading what was being written down. I
Okay.
apologize, Your Honor.
You are not to leave the state of Michigan without permission of the court. You're not just indicated to possess a firearm, ammunition, or anything fashioned to be a weapon. You're not to assault, terrorize, frighten, intimidate, stalk, molest, harass, or stalk anyone. You are to have no contact with Peyton Lee, is it Tralfa? Except with a civil standby with the police. And when I say that, you are also not to have or attempt to have any direct or indirect contact with the above named individual in person or through others. You are not to have contact by electronic communication, but this is including but not limited to phone, email, texting, internet, social media. You are not to refer to that individual in any social media, should say, or online in any. You understand that, sir?
Yes, Your Honor.
You are not to go to the 244 Oakland Avenue in Ypsilanti. I'm also going to indicate that you are not to go to the 1200 State Circle if Miss Trausa is present. That way, I think, could cover it if this extends beyond that. So if she's there, you can't be there. Understood?
Yes, Your Honor.
That's not your home address, but if it were your home address, you would need to find another residence. You are not to violate any criminal law. You're to personally appear at all court proceedings and other places as directed by the court. I will place the defendant, if I hadn't said so, on a GPS tether with the exclusion zone as requested of the Oaklawn Avenue in Ypsilanti. Anything further from others?
What did you want to come?
Nothing from the people.
No?
Transfers.
Like, when you want to go out of state, you'll ask and we'll get position.
Okay.
It's
It happens randomly, so that was my only concern. I can tell them no, I guess.
Are you traveling between now and your next pre-trial?
No, sir.
Okay, and we'll address that then. My client was just saying that every now and then his job would require him to go out of state for transferring a patient or something. And I asked him if he had anything before the pre-trial. He doesn't believe he does. And I know the court doesn't like to give blanket permission on that, but.
Right. And I think if you talk to the prosecutor, maybe or work something out that would allow his travel.
Thank you, Your Honor.
All right. Thank you.
Wait for me in the conference room.
Court does call the case. People versus Dominique Bailey. Yeah. They dropped. All right, I'll wait on that. Quite a while ago.
Yeah, before you took this.
I don't know why they're not here. They were scheduled, they've left. I will issue a bench warrant for failure to appear. Bond will be set in the amount of $1,000, 10%. That warrant will issue immediately. Court calls the case People versus Maggie Cochran.
Not sure.
They're not here. Are these are set for arraignment?
Set for arraignment in.
Got it. So they did receive notice. He doesn't get ordered to show causes, does he?
No, he does not.
Bench warrant will issue for defendant failure to appear, bond 1,000, 10% privilege. That warrant will issue immediately. Court calls case People versus Brian Culver. Over. Mr. Culver, state your name.
Brian Culver.
All right. So you are here for the purposes of arraignment. The complaint in this case alleges that on or about November 24th, 2024, at the location of 7,000 East Michigan Avenue, that being the Walmart in Pittsfield Township, Washtenaw County, State of Michigan, that you did commit the offense of retail fraud in third degree. Do you understand what you're charged with, sir?
Yes.
That is a misdemeanor, punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes.
All right. First question I have for you, sir, is do you wish to be represented by an attorney?
Yes.
Public defender, please.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Culver. At this time, Your Honor, we will waive the formal reading of the charges, be standing mute, and I'll be requesting a personal reconnaissance bond on my client's behalf based upon his appearance here today in court.
Anything from the people?
Yes, Judge. In this case, we just asked for a no-go to. The address would be 7,000 East Michigan Avenue in Saline. It's the Walmart.
Okay.
We'd also ask for all standard bond conditions, including no assaultive or stalking behavior, no firearms, ammo, or components, not to leave the state, do not possess or use alcohol, marijuana, drugs, do not violate any criminal law, things of those nature. Thank you, Judge.
Set the defendant's bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior, possession of any weapons, ammunition, firearms, or anything fashioned to be a weapon. You are not to possess at this time, possess or consume any alcohol, recreational marijuana, or any illegal drug. You understand that, sir?
Yes.
I'm also going to indicate that you're not to go to any Walmart in the state of Michigan. You understand that, sir?
Yes.
I'll set pretrial in this matter for April 15th, 2026, 9 a.m. or as your invite indicates. Thank you. Did he need to go to a breakout room to get information?
I believe so.
Yes, yeah.
Who are we putting him in with?
Maybe, Ms. Vicky, yes.
Who? Okay, fine. Put him in there.
Thank you, Your Honor. I appreciate it.
Yes, sir. Court does call the case, People versus Joe Faulkner. Check in. Joe Faulkner. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege on that. That will issue immediately. Court calls the case, People versus Darrell.
Sorry, I'm here, Your Honor.
What's your name?
Joe Faulkner.
You got it. Mr. Faulkner, you are here before the court on a misdemeanor complaint that alleges that on or about January 12, 2026, location of Clover Lane Drive in Pittsfield Township, Washington County, State of Michigan, you did operate a motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand that charge, sir?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Court should also advise you that your vehicle could be subject to mobilization. Do you understand all of that, sir?
Yes.
First question I have for you is, do you wish to be represented by an attorney?
Yes.
Public defender, yes.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Faulkner. At this time, Your Honor, will be standing mute as to the charges, and I'm requesting a personal reconnaissance bond based upon my client's appearance here today in court and the nature of the charges being a traffic offense. Thank you.
Defendant name away from reading, standing mute, court will enter a not guilty plea. Do the people have any statement regarding bond?
No, Judge.
Bond is set in the amount of $5,000 personal recognizance bond, standard conditions, no assault to behavior, possession of any weapons, ammunition, or anything fashioned to be a weapon, no alcohol, recreational marijuana, or any illegal drugs. I'll set pretrial in this matter for April 15th, 2026, 9 a.m. Thank you. Did he need to go into a breakout room also?
Yes.
All right. Mr. Faulkner, you'll need to wait. We're going to put you into a virtual breakout room so that the public defender can get your information, sir.
Okay.
Thank you. Court does call the case, People versus Darrell Kubiak. Quebec, I think it is. I'm putting syllables in. Sir, your name?
My name is Daryl Kabaki.
Kabaki. I messed that up entirely. Okay. My apologies. All right. Not saying I won't do it again, but my apologies this time. All right. Sir, you are before the court on a misdemeanor citation that alleges that on or about March 6, 2026, at the location of westbound I-94 in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand that charge, sir?
Yes, Your Honor.
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to mobilization. You understand that, sir?
Yes, Your Honor.
First question I have for you is, do you wish to be represented by an attorney?
Yes, sir.
Public defender case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Kabaki. At this time, Your Honor, as we wait to the charges, we will be standing mute, and I'm requesting a personal conscience bond based upon my client's appearance here today in court and the nature of the charges being a traffic offense.
Any comment from the people?
No, Judge, we just asked for the standard bond condition.
Defendant every way formal reading, standing mute, court will enter a not guilty plea. I'll set pretrial in this matter for April 15, 2026, 9 a.m. I'll set the defendant's bond at a $5,000 personal recognizance bond. I will order standard conditions, including no assault behavior, possession of any weapons or ammunition, or anything fashioned to be a weapon, no alcohol, recreational marijuana, or illegal drugs. You understand all of that, sir?
Yes, Your Honor.
All righty, thank you. We will put you into a breakout room so they can get your information, okay?
Thank you.
Thank you, sir. Court calls case People versus Melvin Napier. Melvin Napier. No response. Bench warrant will issue for defendant's failure to appear. Bond $5,000. Give a 10% privilege. Warrant will issue immediately. Court calls the case of the People versus Pauline. Is it Schoener? Oh, there she is. Hello, ma'am. Do you know how to unmute the device? Is that at ours?
Yeah.
Well, ma'am, we're gonna send somebody in to help you out, okay? Oh, you gotcha.
Yeah, I got it. Thank you.
You got it. Okay, you're okay. You can have a seat, ma'am. Hey, you don't have to stand for me. Your name?
Pauline Shaner.
Shaner. Okay. Ma'am, you are before the court on a misdemeanor complaint that alleges that on or about January 6, 2026, at the location of 771 Airport Boulevard, that being the Costco in Pittsfield Township, Washington County, State of Michigan, that you did commit the offense of retail fraud in the second degree. Do you understand the nature of that charge, ma'am?
Yes, I do, sir. Your Honor.
That is because the value, I think in this case, no, because of a previous conviction.
10 years ago.
Yeah, in this court in 2016. This
Yes.
makes this a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value taken. If that's greater than $2,000, that would become the maximum fine. You understand that, ma'am?
Yes, Your Honor.
All right. First question I have for you is, do you wish to be represented by an attorney?
Yes, sir. Yes, Your Honor.
This is a public defender case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Ms. Schroeder. At this time, Your Honor, as it relates to the charges, we'll be standing mute, and I'm requesting a personal conscience bond based upon my client's appearance here today in court.
And then having waived formal reading, standing mute, court will enter a not guilty plea. I will set pretrial in this matter for April 15th, 2026, 9 a.m. as your invite indicates. If people have anything they want to say regarding bond?
Yes, Judge, we'd ask for a no-go to the Costco at 771 Airport Boulevard in Ann Arbor. We'd also ask for all standard bond conditions, including no assaultive or stalking behavior, no firearms, ammo, or components. Do not violate any criminal law, do not leave the state, no alcohol, marijuana, and drugs, and things of that nature. Thank you, Judge.
All right. I think I set the pretrial, didn't I? Yes.
Yes.
All right. Ma'am, I'm going to set your bond at a $5,000 personal recognizance bond. I'm going to order standard conditions, including no assaultive behavior, no possession of any weapons, ammunition, or anything fashioned to be a weapon. There's to be, at this time, no possession of any alcohol, recreational marijuana, or any illegal drugs. I'm also going to indicate you're not to go to any Costco in the state of Michigan. You understand all of that, ma'am?
Yes, I do, Your Honor. Thank you.
All right, thank you. And then hold on the line there. We're gonna put you into a breakout room with somebody from the public defender's office so we can get your information, okay?
Okay,
Thank you.
thank you.
Court calls the case, People versus Tamika Stewart. Tamika Stewart. Your bench warrant will issue for defendant's failure to appear. Bond 5,000, give a 10% privilege. That warrant will issue immediately. Court does call the case, People versus Markeisha Wilson. Markeisha Wilson. 5,000, 10%. That warrant will issue immediately. Court calls the case, People versus Julie. Is it Martarne? Okay, walking on the bench one. Hello. What's your name?
Julie Matarne.
I think this is a PD case.
So, Your Honor.
Please pray and press the agreement. MATARNEH.
If I'm correct, the case number is 1311708, Your Honor.
It is.
Ms. Montane was the one person I did not get to speak to when I was running around during the First Amendment, so I apologize, Your Honor.
No, not a problem. It's been almost 10 years since we should.
Yes, Your Honor.
We may be able to take care of this quickly. Ma'am, where have you been?
Well, I had a daughter, and then I was dealing with the domestic violence for 8 years, and now I'm finally getting my life together. Got a whole new relationship and new life, and I just inherited a large amount of money, so I could take care of my daughter now.
Cancel the bench warrant, I'll reset her bond to $5,000 personal bond. I will set pretrial in this matter. Pardon? Or set pretrial April 15th, 2026, 9 a.m. or as your invite indicates. I will set her bond at the $5,000 personal recognizance. I will just reiterate the conditions of standard conditions, including no assault behavior, possession of weapons, no alcohol, recreational marijuana, or any illegal drugs. You understand that, ma'am?
Yes.
I will also indicate at this time. I don't have an address. Oh, all right. I will indicate also that at this time, you're not to enter any Sam's Club in the state of Michigan. You understand that?
Yes.
All right. Thank you.
What do I do?
14V, just call them so you can set their name.
If the court calls the
They can,
versus Harvey Ruda. Your name, sir?
Javier Ruda.
Mr. Ruda, you are before the court on a felony complaint that alleges 3 counts. The complaint alleges that on or about September 3rd, 2025, at the location of 5301 Macaulay Drive, Superior Township, Washtenaw County, State of Michigan, count 1 is that you did carry a weapon concealed. Do you understand the nature of that charge, sir?
Yes, Your Honor.
That's a felony, punishable by up to 5 years incarceration, a $2,500 fine plus court costs, and does require the mandatory forfeiture of any pistols, weapons, or device. You understand that, sir?
Yes, Your Honor.
The Count 2 alleges that on that same date and at that same location, that you did or were in possession of firearm, and that you are a person prohibited from possessing a firearm. Do you understand the nature of that charge? That's a felony punishable by up to 5 years incarceration, $5,000 fine plus court costs, mandatory forfeiture of the weapon or device. You understand that? Count 3 is the charge that on that same date and at that same location, that you did possess ammunition, and that you are a prohibited person from possessing ammunition. You understand that charge, sir? That's a felony punishable by up to 5 years incarceration, a $5,000 fine plus court costs, and mandatory forfeiture of the weapon or device. Do you understand all of that? First question I have for you, sir, is do you want to be represented by counsel?
No.
Pardon?
Can you say it again? Ask me again.
Do you want to be represented by an attorney?
Yes, sir.
This is public defender.
Yes, Your Honor. Assistant Public Defender Nicholas Bukovich on behalf of Mr. Ueda. At the time, Your Honor, any mute as to the charges, and I'm prepared to address bond when appropriate.
Defendant, you waive any further formal reading?
Yes, I waive any formal reading. Thank you, Your Honor.
And defendant standing mute, court will enter not guilty to this charge. Probable cause conference in this matter will be set for April 9th. April 9th, 2026 at 9 a.m. All right.
All right.
As to bond in this case, anything from the people?
Yes, Judge, we'd asked to a no-go to the address that you had put on the record moments ago. We'd also ask for all standard bond conditions, including no assaultive behavior, stalking behavior, no firearms, ammo, components, or weapons, do not possess or use any devices for creating, manufacturing gun components, do not violate any criminal law, do not leave the state, no alcohol, marijuana, and drugs. And I don't know if he has any weapons currently, any firearms that need to be, that the court needs to know about, that need to be collected from this defendant, Judge.
No, Your Honor.
You don't have any weapons?
No. I'll be,
Mr.
We already went over that, sir. So.
Vukovich, regarding bond.
Yes, Your Honor. At this time, I'll be requesting a person with constant bond. Mr. Ueda has been in constant communication with my office. We do have good contact info. He does have gainful employment. However, he is taking a break from that due to a injury with his ribs. However, he was working at a barber shop, but unfortunately, due to the accident he was in, he must take a break from work. He is a father and a primary caretaker to 2 children who are 5 and 4. He also helps take care of his mother, who is 76 years of age. He does have another pending matter before Judge Sway, which he is on a tether, but has no violations. He's been in compliance the whole time while in front of Judge Sway, and he'll be starting to work again soon. At this time, I would be asking for a person with constant bond.
What's currently before Judge Slay?
Okay.
Well, let me ask this. How long has he been before Judge Slay?
Give me 1 second, and I apologize.
I've been on tether for like 4 months.
Yeah. He has been on tether for at least 4 months, is what he's indicating to me.
Was there a case pending in September of 2025?
Sorry, Your Honor.
No, it's okay.
From a note from my colleague in his prior interview sheet, he thought he was arrested for both of these cases since December, spent some time in jail, and then this case was later authorized.
So both cases happened at the same time?
Yeah,
Okay.
I believe both cases happened around the same time.
My old case?
Yes.
You know, my old case is like 4 years old, 3 years, 4 years old. The one I'm
The one that you
And Taylor is like 3 or 4 years old.
Yes. So I think, okay, my understanding then is his other case is a bit older, but he was arrested, but he thought was at the same time for these two offenses. So I do not believe he was on bond at the time of this new alleged offense. I think he was arraigned on the 2023 case closer to the September 2025 date.
So he wasn't on bond at the time of this case?
That is my understanding, Your Honor.
Did the people dispute that, or?
Judge, I'm still, I can't even locate the name because I don't even know the spelling and I don't have a list of.
His last name is Rueda, Rueda, Senior. It's Javier is his first name.
Thank you, Judge. I'm looking it up right now.
Never.
And it's RUDEA.
Rueda.
Okay, and what was the question, Judge? I'm sorry.
Was he on bond on his previous case, time of this offense? This offense occurred September 3rd of 2025.
Case. No, I was when I came to the new case at the hospital.
That's right.
I was not in bond. I just they arrested me for the old case.
Yeah, that's what that's it.
And they charged me with a new case.
When you
go.
Yeah, that's how I just explained to his honor.
So I was in the hospital when the new case happened.
Good. Sir, are you on parole, Mr. Allen?
No. No.
Were you on parole?
No. I was a long time ago, but I'm not. I ain't been on parole, probation, and then.
I have here that the defendant was outside Trinity Hospital with a 3-year-old child. Called and reported that the defendant was actually actively overdosing while sitting on a bench. The police, upon searching him after attending to him, found his parole ID card as well as 7.75 grams of suspected cocaine, as well as 20 rounds of ammunition. So it appears to me that not only was he in possession of firearm or weapon or ammunition at the time, but he was under the influence. At the time that this offense was occurred, he was on warrant status for that previous CCW in circuit court.
Yes, Judge, that's what I just wanted to say. That's what my notes are showing as well.
Right. I'll order standard conditions, including no assaultive behavior, possession of any weapons or any stalking type of behavior. There's to be no alcohol, recreational marijuana, or any illegal drug. If he's on a tether on a circuit court, I'm not going to order a tether. I will indicate that the defendant is not to go to the 5301 Macaulay Drive address except for medical attention.
Yeah.
I'm just in the hospital. So that's absolutely when I went back in there because I broke my ribs.
Yeah.
Oh, I can't work.
You can go for medical attention, is what you said.
Oh.
All right. I will, however, indicate that the defendant was on warrant status at the time that this was picked up, as further indicated he was actively overdosing. So I think it's important to point out, not only was he in possession of these firearms and ammunition, but was so in possession of those with also the presence and actively using narcotics at the time. So therefore, the defendant's bond, I'm not going to grant a personal recognizance bond. I'm going to set the defendant's bond at a $5,000 cash or surety bond. So he'll need to post that prior to leaving. Go with my bail. So
5,000.
5,000 cash or pardon? No. Court calls the case People versus Ahmad Issa. Why are they on this? You should only be giving whatever date is.
This was a felony review.
I know it gave, but I don't know why it was giving two different dates. We'll move that one. Ahmad Issa.
Sure.
Seriously, you are before the court on a felony complaint it's a 2-count felony complaint that alleges that on or about March 7th, 2023 at the location of 3020 Washtenaw Avenue and also at 2190 West Michigan Avenue. Number one, that you did commit larceny in a building. Do you understand the nature of that charge, sir?
I do not.
Pardon?
I don't understand the nature.
Okay, here we go then. The complaint alleges that on March 7, 2023, at the location of 3020 Washtenaw Avenue, and I think also then there is a transaction which occurred at 2190 West Michigan Avenue. Count one alleges that on that date that you did commit larceny in a building, specifically states that you did commit the offense of larceny in a Crunch Fitness by stealing a credit card, cash, contrary to Michigan statutes. Do you understand now what you are charged?
Yes.
That is a felony, punishable by up to 4 years incarceration, a $5,000 fine plus court costs. Do you understand the maximum penalty?
Yes.
Count two alleges that on that same date and at that same location, that you did knowingly retain and knowingly possess or knowingly secrete or knowingly use a financial transaction device without the consent of an Austin Bryant, the device holder. That is commonly known as stealing or retaining without consent a financial transaction device. Do you understand the nature of that charge?
Yes.
That is a felony, punishable by up to 4 years incarceration, a $5,000 fine plus court costs. Do you understand those maximum penalties?
Yes, Your Honor.
First question I have for you is, do you want to be represented by an attorney? It's the public defender case.
Yes, Your Honor. Assistant Public Defender Nick Bukovich on behalf of Mr. Issa. At this time, Your Honor, will waive any additional formal reading of the complaint, restanding non-proceedings as bond and appropriate.
Defendant having waived further reading, standing mute to the charge, court will enter a not guilty plea. I'll set probable cause conference in this matter for April 2nd, 2026, 9 a.m. Yes, ask anything from the people regarding bond.
Judge, we'd ask for a no contact with the victim and a no go to the address. We'd ask for all standard bond conditions, including no assaultive behavior, no stalking behavior, no firearms, ammo, or components. Do not violate any criminal law, do not leave the state, no alcohol, no marijuana and drugs.
Mr. Bukovich.
I got you. At this time, Your Honor, I would be requesting a personal reconnaissance bond on my client's behalf. My client has no prior criminal history. He does work full-time doing medical sales. I would be requesting that he be able to return to Ohio. His primary residence is in Ohio. This is a slightly older offense, with alleged offense in 2023. After conversations with my client, I believe we do have some strong possible offenses to it. As indicated again, he has no prior criminal history. He is here today purposely availing himself to the court to get this matter handled. He's driven about an hour and a half from Findlay, Ohio to get here to get this warrant taken care of. So obviously he is showing that he takes this matter very seriously. And if I recall correctly from reading the bond form submitted by the prosecution, there was no objection to a conditional release without any cash components. So I believe a PR bond is appropriate.
I will set the defendant's bond at a $5,000 personal recognizance bond. I will order all standard conditions, including no assaultive behavior or possession of any weapons. You understand that, sir? You understand that this time you are also not to possess or consume any alcohol, recreational marijuana, or any illegal drugs. You understand that?
Sure.
I'm going to indicate that the defendant is not to go to 3020 Washtenaw or to the 2190 Michigan Avenue address. You understand that, sir?
Sure.
I will order that the defendant may return to Ohio to reside, but he must attend all court proceedings or places as directed by the court. You understand that?
Sure.
Right. Thank you.
Thank you. Okay. Can you repeat that quote there one more time, Your Honor?
Court date?
Yes.
April 2nd.
April 2nd. Thank you.
Thank you.
Thank you, Your Honor. Appreciate it.
Court calls the case People versus Diamond Byers. Oh, there she is.
Yes.
Hello, what's your name?
Hello, Diamond Buyers.
All right, ma'am, you are here before the court on an arraignment on two felony, there were felonies, yes, two felony complaints. First one, that being 26 FB 1025, that complaint alleges that on or about December 17, 2025, at the location of 3020 Washtenaw Avenue, that you did knowingly retain, possess, or secrete a financial transaction device without the consent of the owner. Do you understand the nature of that charge, ma'am?
Yes.
That's a felony punishable by up to 4 years incarceration, a $5,000 fine plus court costs. You understand that?
Yes.
Is that a yes?
Yes, I'm sorry.
The other case, that being 126F 0190, alleges that on or about August 10th, 2025, at the location of 2723 Oak Valley Drive, Pittsfield Township, that on that date you did knowingly retain without the consent of the owner of a financial transaction device. Do you understand the nature of that charge?
Yes.
That's also a felony punishable by up to 4 years incarceration and or a $5,000 fine plus court cost. Do you understand that? First question I have for you on both of these matters, do you wish to be represented by the public defender? These are public defender cases. Go ahead, Mr. Buckley.
Yes, Your Honor. Assistant Public Defendant Nick Buckovich on behalf of Ms. Byers in both matters. As it relates to a formal reading, we will waive any further formal reading in both matters. We'll be standing mute, and I'm prepared to address bond when appropriate.
Defendant able to waive formal reading, standing mute. Court will enter a not guilty plea. I will set probable cause conferences in these matters for April 2nd, 2026, 9 a.m. Any issue regarding bond from the people?
Judge, I would just ask for a no-go to the 3020 Washtenaw Avenue address on the first case, and then the 2723 Oak Rally address on the second case. And then we would ask for all standard bond conditions, including no assaultive and stalking behavior, no firearms, ammo, or components, do not violate any criminal law, do not leave the state, no alcohol, marijuana, and drugs. Thank you, Judge.
Mr. Buckovich.
Yes, Your Honor. At this time, I'll be requesting a personal conscience bond in both matters. Ms. Byers is currently a nursing student. She also does work full-time as a caregiver. She is local to the area, so she's not a flight risk. When she was made aware of these warrants by Mr. Drukas, who's representing her in another matter that'll be before Your Honor tomorrow, she came very quickly to take care of these matters. There's even a misdemeanor warrant that she's already paid the bond on, showing that she takes these matters very seriously, and she's trying to resolve all her outstanding matters. So at this time, Your Honor, I would request a personal conscience bond in both matters. I believe there be no issues of no context and no go-tos in any matter.
Wasn't on bond at the time of these offenses. course. Yeah. See.
To my knowledge, no, she was not there.
You said she had something else before on the warrant status when these occurred? I mean, because you said she has other cases.
Yeah, I had a misdemeanor warrant for retail fraud that I paid the $1,000 today for when I walked in, and then Edward said,
When did that warrant, you see it? I got that. What's the date of that? Yeah, well, the date of the warrant.
December 17th, 2021.
also was showing up for all my other court dates during that time.
Yeah. Yeah, my client has indicated that she has been paying to all of other court dates at a time, and that Mr. Dukas was doing this so we can consolidate all the cases and get everything on the same track.
Anything else from the people?
No.
Set the defendant's bond in each of these cases at a $5,000 personal recognizance. In each case, I will order standard conditions, including no assaultive behavior, no possession of any weapons, ammunition, or anything fashioned to be a weapon. I will order also no alcohol, recreational marijuana, or illegal drug use. You understand all of that, ma'am?
Yes.
In the case ending in 1025, I will order you to have no contact with Brian Coons. And you are not to go to 3020 Washtenaw Avenue. You understand that? In the other case, I will order that you're to have no contact with Renee Price, and you are not to go to the 27230 Oak Valley Drive address. You understand that, ma'am? All right. Thank you.
Thank you. So I still show up to court tomorrow for the.
Yes.
Okay. All right. Thank you.
Right.
She has cases tomorrow.
I believe she has a PCC tomorrow. Yes. She wanted me to.
A second. I didn't understand what you were telling me. Come back up, man.
Yeah, they're yes.
You were trying to get them all together, correct?
Yeah, it's possible. I did speak to her. I did understand if you can't get them on the docket tomorrow with such short notice, and we did speak about that. Correct, Ms. Barnes?
Yes.
I mean, I will set them. I mean, you guys are on these.
Yeah, and one of them we may have the conflict off of as well. Just by
I have to.
Just by my quick review of the complaint, I recognize the co-defendant.
Got it.
I think it's the same by Mr. Dukas is on all your other matters.
Yes.
How many are set for her tomorrow?
3 year on all insurances.
Okay, I'll tell you what, let me reset these tomorrow. Let's try to get everything together.
Yes, please.
So I'll set these for tomorrow. So she'll have all of those. And Mr. Bukovich, if we can try to get approval on the conflict and see if we can get that resolved so we can get her.
Yeah, as soon as I'm out here, Your Honor, I'll try to get it done for you today.
I know you will take care of it. So 326, I'll set your probable cause conference for then tomorrow on this case.
Great.
Have all of them. All right.
Okay, how you want it?
All right. Okay.
No problem. Have the rest of the day.
Court does call the case. Zonaida Javiera here. Tepe, not present. I will, in each of these cases, then issue back warrants for the defendant's failure to appear. Bond it will be set in the amount of $5,000. I'll give a 10% privilege. Those warrants will issue immediately. All right, I think that's all I have.
Yes, sir.
All right, that's it. Ms. Woods, thank you very much.
And then Judge, I'm back at 1:30, correct, for the afternoon arraignments?
You're back
Or I'm
at
sorry,
1:30?
1
You're
o'clock?
gonna come bother me at 1:32? No, I'm kidding.
I'm sorry, at 1 o'clock, I mean.
At 1 o'clock, yes. We'll see you then.
Thank you, Judge.
Thank you. Court stands in recess. You guys.
Soon to be 23, right? I'm gonna do this for you. I'll waive your balance. You didn't commit any crimes while you were on probation, did you? Where do you live?
2-4 now, May 1st.
Who do you live with?
Flat Rock, Michigan.
Who do you live with?
My sister and my brother.
And your what?
My big sister and little brother.
Big sister, little brother? Are your parents around? Okay. Okay. Just wait a second. I'm gonna help you out. Why? I don't know. Stop acting like this, young man. You're gonna go take care of these other warrants, right?
Yes.
Are you gonna go take care of these other warrants?
Yes.
Today?
Yes. I got a report.
Where?
You won't feel good. I got a report.
Jeez, you're going all over the place. All right, give me a second. What's this gentleman's name here, Jeff?
What's your name, sir?
The one on Zoom, Judge, he's a victim on the Jeremy Christian case.
Okay, good.
Grinder, no, Mr. Gabe, he's on.
Is Jeremy Christian here?
He's being with Mr. Gabe now.
Okay, I want him to come in because I'm gonna end up adjourning this. That one.
Christian?
Yeah, and I'll explain it when he comes in.
Okay.
Bear with me 1 second, folks. All right, you filled out that document for me? All right, young man, I'm gonna go ahead and dismiss the case on motion of the prosecutor. I'm gonna waive your balance. Don't come back and see me unless you wanna tell me that you're running the Pentagon or something. You got it?
Okay.
Case dismissed. Good luck.
Thank you.
Thank you. Give me 1 second. I'm gonna get the lawyer in here. I'm gonna call the case and I know what I'm gonna do. The victim's here and I'm gonna adjourn it, tell him.
He's on one.
And what are you here on? You,
He's seen Mason. He's waiting for Mason.
okay.
No show, security, but every client to.
I don't want to get in the habit of that. Too much will get messed. 57. Yeah, I wrote the wrong date. I did write March 25th of 25, but your appearance,
Caitlin Fully Carter, Boston Township.
defendant failed to appear. We're going to issue a show cause regarding why conviction should not enter. I mean, I guess this one's a little different. Do you have his phone number by chance? should not enter for failure to appear for review hearing. So that's what I'll do. We'll set it on the next docket. Okay, Heather?
Okay, Judge. So you want me to
Thank
put
you.
it on the 8th then?
Yes, please.
Okay.
Thank you.
Thank you, Judge.
Thanks.
I called him around.
Did your lawyer tell you to come in here, sir? Just bear with me a minute, please. Look at that. The lawyer. All right. Mr. and Mrs. Barbarich, is it? You're muted. I'm just telling you to bear with me. I'm waiting for the lawyer.
Okay, okay.
Okay. Hand me those, all right. I want to tell you what has transpired here. Just give me the Christian. Jeremy Javon Christian. And I have these files, 21B138966A, which is a sentencing that is to take place on a reckless driving. I also have on 21B139004, I have a sentencing date on a resist and obstruct an officer. And then I have probation violation on the operating while impaired charge. Everybody's names. Let's start with you, Mr. Gates.
Good morning, Judge. I'm asking you to back Mr. Christian. The Christian state your full name. There, Chris.
All right. Can I have you, were you both in the vehicle?
Correct.
Can you both tell me your names?
Diane Barbarich.
Lawrence Barbarich.
Our son was in the vehicle too. He's away at
He's what?
college.
All right. So this was brought to my attention yesterday, that somehow the probation officer caught it, or the probation secretary, I should say, caught it. We had not notified the victims of their opportunity to appear here today. And she called them. And so my understanding was that and I want you to correct me if I'm wrong in any aspect here, that you guys wanted to appear, or I think you expressed to the probation secretary, Mr. Barbarich, that you wanted to appear in person. Is that true or false?
Well, I don't want to delay any proceedings if that's going to delay it by me not being there today. If you can proceed today, that's fine.
I mean, it's up to you. I can delay it a week or two, and we can pick a day that's on a Brownstown docket day that's kind of convenient for you too. And besides, I don't know if your son was notified, if we should have notified him. And he has the right to appear as well. So I feel uncomfortable unless you tell me, Judge, my son knew and doesn't want to make a statement or what have you.
Well, he's away at college right now, and so he's
in another state.
He's in Ohio, so.
The funny thing is, we can Zoom with people in Alaska. I've Zoomed with people in Italy before. So if I can reschedule this, this is what I'm going to suggest. I'll reschedule this to my next Brownstown docket day. I will give everybody a time when they can appear, and we will go from there. And then I'm going to ask you to give me your son's address to notify him. So Heather, what if we do 2 weeks from today, which would be April the 8th?
Judge, Mr. Christian had to take off work today, and Is there any way to schedule this in May when he would be able to use some of his vacation days to appear? Because he's pretty much.
I don't know, personally, no vacation, I just got back to work, so I don't want to be vacation too.
Well, here's the thing, Judge. We took off work today too.
Well, I did.
If you guys, listen, if you guys want me to sentence today, everybody, I'll be glad to do it. I just wanna, I feel bad that you weren't properly notified when he finally came in on this case.
Yeah, because
And then the probation secretary explained everything, that you wanted to be here. And if you guys wanna stay, if you guys wanna just give me your statements by Zoom and you're comfortable calling your son and telling him he can Zoom in, I'll be happy to do this. I'm not trying to be an obstructionist here, but your son has the right to make a statement too. And if we didn't notify him, our bad. And I want to do it right.
I mean, I would like to get it resolved today too. I could try and text him and give him.
Let's do this. Why don't you text your son? I'm gonna get off the bench. We'll take a few minutes. And you call him or text him and see if he can appear today. If he can't appear, I'm gonna adjourn it unless you also tell me he's aware and he doesn't care to appear for sentencing. Okay?
Or he helped us get the Zoom app installed on the phone.
Well, let's do that. We'll see if we can get him on here.
Right. I'll pass the case a few minutes and I'll accommodate everybody here. I'm not trying to delay anything. So that's what we'll do. Okay?
Judge, can we take care of Mr. Griner?
I'm going to Shane Griner. Brian Shane Griner, 25B149678. Steve, 25B149713A, B, and 25B149678A.
Good morning, Judge. Doesn't get past here and have Mr. Griner. Mr. Griner, say your phone.
Brian Shane Garner.
Where's he been?
Judge, he's had some medical issues. He's got broken back. He cares for his mother, who's also got a terminal illness, Judge. So he's been off work and he's just been preoccupied dealing with his mother's situation.
And I also have 678B, by the way. So what do you want to do? Just adjourn it?
We're looking to adjourn just to get some discovery to verify some.
Yeah, I'll do that. All right, we'll adjourn this. We'll adjourn this to April the 8th, Heather. Can you give me a time?
Sure, Judge, we could do 10:15.
At 10:15, okay? Now, I'm gonna tell you right now, you have these other cases that you owe money on. The expired plate, you owe 213 and you owe 327 on the no insurance to include your or thereabouts. It might be 362 now. So when you come back here, I'd have the money, okay?
I can pay 100 today. I don't know if I'll have it all at then when I come back, but I can pay 100 right now. Or something.
All right, here's what I'm gonna do. Defendant to pay 100 now on the expired plate.
Just get on Zoom. What are you doing right now?
And I'll adjourn that to the same date, April the 8th. Okay?
Thank you, sir.
And you come back with as much as you can then, and we'll take care of these, all right? Good.
Thank you.
Thank you. All right, the court's in recess.
Yeah, you can take it the same.
Yeah, thank you.
Yeah, they'll take it.
Yeah. Good luck.
Thank you.
Do you want us just to kind of hold on this one?
Yeah, I mean, you can just, do you have any other cases?
No.
Okay, so you should know in the 5 or 10 minutes.
No problem.
If you want to go do something, come back at 15 after, I'm fine with that too.
Thank you. Okay.
Client there.
here from a date. Bond Christian 21B139004. That is from a date of June the 13th of 21. There was a no contest plea tendered on 8/17 of 22 to resist and obstruct an officer. Then I have the reckless driving charge that happened on June the 13th of 21. And again, on August the 17th of 22, defendant pled no contest to reckless driving. And then I also have here a violation of probation on an operating while impaired charge, which the defendant was sentenced on back on March the 17th of 21, I believe. Yes, March the 17th of 21, and then did not show up for a probation violation hearing on September 8th of 21. So I can take them in whatever order you want to go.
Yeah, if the court wants to start with the reckless driving,
We'll do that. And the resist and obstruct. So everybody can state their names, please. Your name, Mr. Gaith?
Good morning, Judge. Nice to get bring back Mr. Christian. Christian, say your full name.
Christian. All right, your names, please.
Diane Barbarich.
Lawrence Barbarich.
Adam Barbarich.
All right, so the June 13/21 incident, there was a no contest plea, and then he failed to appear for sentencing at least once or twice. And so we haven't had him here, but at any rate, I did not order on that
The PSI.
I didn't order a PSI, I don't believe. So I just had a sex date so the victims could be notified. They were, and then it looked like he came in on August the 31st, but left. And then I had him set it in person, and I made a note that Diane and Lawrence Barbarich were here. Be sure they were notified September 14th of 22. And then again, he didn't show up for sentencing. So that's where we are with it. I've read the report. I'm talking about the police report. Have you?
Yeah.
All right. Anything you'd like to say?
Judge, Mr. Christian at that time had become homeless. He was homeless in 22 through 25. He was laid off. And then he ended up, there was an incident in which he was shot in the hand, and he became disabled for 6 months and unable to work. Then he became laid off and actually just went back to work about a month ago at Chrysler. He does have an 8-year-old child that he shares custody with the mother. And he is financially responsible for that child, Judge. And between his lack of stable residence and everything else that can go on, I believe that's the reason why he had missed and failed to appear in that direction.
Okay. Anything else?
Just that, at the time that he took the plea, obviously, looking back now, I know it did indicate that he would maybe have pled differently, but I did advise him that we're at this point now, and we need to move forward.
What it mean? I don't know what he means by that. They got him going over 100 miles an hour and rear-ending a vehicle, an Impala. I mean, you know what? Anyway, all right. Anything you'd like to say? Anything either one of you would like to say? Let's start with you, Adam. Do you have anything you want to say?
Yeah, I want to say it almost just feels like a miracle that we're alive, because I mean, I was sitting in the back seat when it happened, and I was like 16 at the time, and we were coming back from a long weekend of baseball, and we're all tired, and we're just trying to get home, have a 3-hour drive, and we're just driving in like one of the middle lanes. Maybe it's like a 4-lane highway, and I'm on my phone, just kind of leaned over in the back passenger seat, and then all of a sudden it's just big bang. And it just felt like we were spinning forever, just spinning on the road. And I don't know how we didn't get hit. It just feels like a miracle to me. And we went across, it was a lot of traffic. We went across the whole lanes and slammed into the median. And I was scared for my parents' lives. I was fine. The first thing I asked is, are they okay? And I think they hit their heads, but they were fine. Everybody was just kind of dazed. And the first thing I thought was trying to get out of the car, but our car, the door that I was by wouldn't open. So I had to get out of the door that was kind of against the median and squeeze out. And the car was just absolutely crushed, and made sure my parents could get out. And we got out, and first thing I noticed, I look at the car and the tire was catching on fire. And I was able to put it out before it caught the whole car on fire. And, it's just like these little things like this. It's just a miracle to me and makes me look at life completely different now. And I had no idea what happened. And we had people coming up to us, and they were saying that, this guy hit us. He was speeding down the road for miles. They knew they were going to hit somebody. And then they said he went off the road, further up the road. And somebody said that he had a kid in the back of the seat. I couldn't believe what was going on. And he took off on foot. But I mean, I don't know what to believe or anything. I was just lucky to be alive, and my parents were safe. And that's all I pretty much have to say.
Mr. and Mrs. Barbarich, would either one of you or both of you like to speak?
What does no contest mean exactly?
No contest essentially has the same effect as a guilty plea, but what it does is there's certain circumstances that it's appropriate to take a no contest plea in, and that is if there's a possibility the defendant can be sued, or if there is, which there certainly would appear to have been here, nobody really quite knew what the injuries were, but he's driving over 100, they said, and I just heard what your son said. And then the other one is if they don't have a recollection due to intoxication or drug use or whatever the case may be. But it has the same effect as a guilty plea. Instead of the judge asking the defendant questions, in this case, I would have reviewed the police report and made a determination based on that, because we have to make sure when somebody pleads to anything that there's a valid basis for the plea, what we call a factual basis.
Okay.
So, do you want to say anything else?
I'm just curious why he was driving so fast, like, with a child in the car. I mean, as a mother,
I understand. Sir, do you want to say anything?
Yes, sir. I'm a retired Detroit fireman, 35 years. I retired as a battalion chief. I've seen a lot of horrible things. And when that happened, I thought it was over, and I was afraid. I was afraid to look in the back seat at my son. And I'm just thank the Lord everything's okay. That's all I gotta say.
Does anybody have any out-of-pocket expenses? Anything you had to pay for that was not covered by insurance?
No.
I mean, just a few days of loss of work, but I mean,
If you lost any wage,
the co-pay or whatever for the deductible, I don't know.
Well, I mean, if you have any out of pocket, I can't order wage loss because that was recoverable through your own insurance carrier, believe it or not.
Yeah.
Even though he was completely at fault. But I'm gonna let you two think about it and Mr. Barberich, and I wanna do all of these at the same time. So we have on the operating while impaired, I've got multiple violations. Failure to attend the scheduled probation visit on August 18 to 21. Failure to attend the victim's impact panel. Failure to attend the court work program on August 4 of 21. Failure to pay fines and costs as ordered. Failure to refrain from consuming alcohol or drugs, testing positive for alcohol on August 3. Failing to clear all warrants. Failing to provide verification of attending AA twice a week until an IOP, and failure to provide verification of attending and completing outpatient treatment. So I'd like to either have a hearing on those or take a plea on those, whatever he fancies. So how's he going to proceed on that?
You can't take a plea.
Is that what you want to do, sir? Since you absconded, you could get 93 days here. Do you understand that? You got to keep your voice up for him. You are presumed innocent. They have to prove you guilty, Colin Bell. By a preponderance of the evidence, you have the right to question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses, and the testifier remain silent. If you remain silent, that silence would not be held against you. By pleading guilty, you're giving up all those rights, and we are not going to have a hearing. Do you understand that? Any questions before I ask you how you plead on this?
No, sir.
As to count one, that you failed to attend your scheduled probation visit on August the 18th, 21, how do you plead?
Yes.
Did you fail to attend your probation visit on that day?
Yes, sir.
Count two, that you failed to attend the victim's impact panel, how do you plead? You failed to attend the victim's impact panel.
No.
You went to the victim.
Yes.
Not when it was assigned, Judge, but he did make it up. But at the time, yes, he did fail.
Did you fail to attend back when you were on probation?
No.
Or in that time frame when you were given?
Yes.
To count three, that you failed to attend the court work program on August 4th of 21, how do you plead?
Yes.
You failed to attend the court work program on that date.
Yes.
To the charge, you failed to pay your fines and costs as ordered, how do you plead?
Yes.
Failed to pay your fines and costs as ordered.
Yes.
Count five, that you failed to refrain from consuming alcohol, testing positive
Yes.
on August 3 of 21, how do you plead?
Yes.
Did you consume alcohol, say within the 3 days before that test?
Yes.
And count six, that you failed to clear all your warrants, how do you plead?
Yes.
Count seven, that you failed to provide verification attending AA twice a week until an outpatient, how do you plead?
Yes.
Count eight, that you failed to provide verification of attending and completing intensive outpatient treatment, how do you plead? Did you fail to attend outpatient treatment?
Yeah.
Did you fail to clear all your warrants? Did you fail to attend AA twice a week until an outpatient?
Yeah.
Intensive outpatient. Anybody force you to plead guilty? Anybody promise you to induce you to plead guilty? Please accept the all 8 counts. Heather, I need to know how much he owes on those now.
On his probation case, he has a balance of $813.
All right, now I'm going to ask, and again, all of these would be deemed non-technical since you absconded. So you got 8 non-technical violations. Is there anything you'd like to say
Judge, with regard
on any of these?
With regard to count two, failure to complete the victim impact panel, he did complete that in July of 24. And then as far as the count 3, he did complete that also in 2024. He doesn't know exactly when. With regard to count 4, the issue with the unpaid balance, there is a bond posted against this case, Judge, that will hopefully clear up a majority of the outstanding balance. With regard to count 5, he's pleading guilty as charged with regard to the positive test and the alcohol. With regard to count 6, Judge, the warrants, according to Mr. Christian, he's cleared the majority of them. He believes He does have three or four that are left outstanding. And that's only been financial issue because he hasn't worked. He's only been back for like a month. With regard to counts 7 and 8, he wasn't able to get into the outpatient treatment program because his insurance wouldn't cover it. And again, Judge, financially, he wasn't able to afford to pay for that out of pocket. He's trying to make up for whatever he was able to do now. But again, Judge, mainly it wasn't so much in front of his nose at the court other than his being financially unable to pay for these and get them cleared. It was a financial issue.
Anything you'd like to say?
And I'm still currently actively trying to get taken care of my life as far as my license. I'm trying to get my license back, but I can't get my license back because of directed driving to the year. It's the only suspension that's holding my ticket me back from getting my license. So I've talked to Secretary of State about what happened that, and the other tickets that I had were for a driver suspended license. So once I get my license, go back in, try to see this again.
Well, Janine,
Elizabeth Ross-Christian.
anything you'd like to say?
Yes, Your Honor, and I might be able to offer up at least a little bit of clarification, maybe even some help from Mr. Christian. So he was in front of Judge Hesson. I don't know if this was already addressed, but he was in front of Judge Hesson July 11th of 24. She reiterated bond conditions. He did come down to probation on July 11th. I re-instructed him in regards to his treatment, chemical testing, and I did schedule him for 3 days on the court work program. He was instructed on 12-step meetings at the time as well. So as of that time frame, he was given a court date then to come back August 28th. He absconded and the bench warrant was reissued. Between that July 11th date and August 28th, Mr. Christian did do the 3 days on the court work program.
Was she talking about, I see that she was the one at one point that arraigned him on this charge, these charges. Was that court work that she told him to do, was that on these cases or was it on a case in front of her?
Not on a case in front of her. This was addressing her bond on the probation case, which would have been this one here. Judge Hesson will often reiterate probation terms as part of bond. And she ordered the 3 days on the court work program because those were the days he had remaining out of the 4 that he was to attend.
He had gone to one before that?
He had done one on August 4th, 21.
So he actually has 5 days credit coming on these.
He has 4 as far as court work program.
Plus the 1 day credit from the arrest.
He did show for 1 chemical test after bond. He was positive for marijuana, negative for all other substances, but absolutely no proof in regards to victims impact panel, 12-step meetings, or treatment.
Judge, he does have the certificate of completion for the victim impact panel.
Okay. Do you have that with you, sir?
It's in my phone. I have a login.
I'll take it your word on that. No, I'll believe you. Folks, would you like to say anything else? Yeah, you could say something to them.
To you, I'm sorry about the event that happened. It was very foolish on my behalf. And since then, I've learned I know I do it. I had a younger child at the time, and I understand the pain to a younger child. I just want to say that I'm sorry.
Where are you going to school at, young man?
University of Northwestern Ohio.
Well, what are you studying?
I'm actually doing 2 degrees. I have automotive and high performance technology, and then hybrid and electric vehicles.
Good for you. Anything else anybody wants to say over here?
Yes, sir. On top of what happened to us, the defendant, he had a 2-year-old in the car, in the back seat, and he ran from the scene. I was told by civilian bystanders. And I guess some bystanders tackled him or something that I can recall, but I can't even imagine that, leaving a 2-year-old on the expressway like that and just running away. That was on top of what happened to us, but I just wanted to say that too.
Judge, I want to correct the record. Actually, his child, when he left, he wasn't running from the scene, Judge. He actually took him and they went into the ambulance and they were taken to the hospital. So I don't know where the information came from, but he was tackled. He actually went to the emergency responders and actually got in the ambulance with his child and they were transported to the hospital.
Okay, so I want everybody to understand, unless somebody speaks up and says, Judge, we have this much coming in restitution, I'm not going to order any. Does everybody understand that?
Yeah.
Well, I'm talking to the victims.
Yes, sir.
All right, and you understand that, young man, and Mrs. Barbarich?
Yes.
Yes, sir.
I don't know what to say to you, Mr. Christian. There's a whole lot of issues I have with your conduct, your failure to appear, your failure to show any respect for the court. And the more I look at this, the more I think about this, I mean, this is laughable talking about whether or not you get another day off or you have to wanted to wait till May if I was going to adjourn it past today because of a vacation. Or lack thereof, vacation time. You can't do this. You cannot do this. You cannot do this. You're driving around with a 2-year-old in the vehicle and you're acting like a maniac. And I could see the terror on their face just looking at them. And then you blow us off with probation, like I'm the kind that's going to put up with that. You blew us off, sir, and you got a big price to pay here today. I'm not going to assess any fines on the resisting obstructing officer. I'm not going to assess any fines on the reckless driving. I'm simply going to give the defendant 15 days jail on the resist and obstruct, and that will run with concurrent with 21B138482A. I'm going to give the defendant 45 days jail on the reckless, and that will run concurrent with 21B138482A. On the operating while impaired, I'm revoking your probation. You're to pay costs in the amount of $800 and serve 93 days, credit 5 for 88. If you pay $800, so if you get somebody to bring up 800 or sign over their bonds, that will suspend 18 of the 88, and you'll only have to serve 70. But you're in custody for 70, you pay 800. They will all run concurrent, Heather. Yep. You pay 800, you'll be out in 70. Otherwise, you're going to be in for 88.
I'll be out in 70.
70. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Yeah, we're going to let you make a phone call. I'll let you. There's nothing I'm going to do. You spat on the court. You drove like a maniac. There is nothing I am going to do to change my mind. The only thing I could do or would do if I could is call the legislature and tell them to retroactively make this a lot more serious, because I'm only giving you that because that's all I can give you. There's nothing I'm going to do to change, you're going to do to change my mind. So I'm going to ask you not to speak. You can talk to a lawyer on appeal if you want. You can't blow off courts for 3-4 years, and you just can't do that. So there's nothing else. Have a seat. Good luck. Thank you very much. Thank you, folks. Have a good day, and I wish you all well.
Thank you.
Thank you, sir.
Thank you, sir.
Good luck, young man. Study hard. Don't run against me, though.
Thank you.
See ya. Thanks a lot. Thank you.
The only case holding me.
That will be due and payable. I'll just make it 60 days after release. You'll need to get in contact with probation regarding a payment plan. There should be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to reside in sober living, comply with all house rules and requirements with status reports to probation. You're to begin and maintain employment. You are not to go to any McDonald's. Well, you're not to go to the McDonald's at 3811 Carpenter Road, Ypsilanti. I'll order 90 days in jail. Credit 53. The balance is suspended.
Right. Thank you. Thank you, sir.
Oh, yeah. Put a pin in that one. Court calls the case, People versus Mario. Is it Triani? Did I get it? See?
Morning, Your Honor. Michael Vincent. Good afternoon, Your Honor. Michael Vincent, F. Ariel Triani.
Not gonna get it.
Go on. No, hold on. Was it pretty good?
Mario Triani.
All right.
I'll take my word for it. Well, we both, Michael Vincent and Mario Triani, what our names on the record.
Right over the pre-sentencing.
Yes, may we approach?
Sure.
Come on, me.
You had a bench conference. Anything either of you'd like to say before I impose sentence?
Mario had some difficulties a few years ago. He's been clean and sober over 2 years now.
Yes, Your Honor. I got sober in March of 2024. June of 2024, I had a horrible accident.
I explained that too.
Okay. Since then, I've stayed sober. I'm regularly in high gear program through therapy, counseling, and others just to stay sober, just to make sure that my life is straight. Got my family back now, and I'm on the right path to righteousness, basically.
That's good. One of my sons knows Mario and verified everything he said.
I also have a letter from High Garrett, and I wrote a letter to the court as well. So
I believe you because I know Mr. Vincent would have told you the worst thing somebody come lie to me. Right.
I tell us, I preach that to everybody.
All right. Sense of the court, I'm gonna do this. I'm just gonna charge the $125 state fees, the minimum I can charge. And then 365 days in jail suspended. Good luck to you.
Can you have some time to pay that?
Why don't you talk to Miss Blair about?
I can pay $50 today.
Oh, just
No.
talk to Miss Blair.
Thank you, Connor.
All right.
Wait for you outside.
Court calls the case, People versus Michael Napriel.
Just let me first.
Ron Brown appearing on behalf of Michael Napriello.
Your name, sir?
Michael Napriello.
I shared the pre-sentence investigation report and recommendation with him. There are no changes. We'd ask the court to follow the recommendation.
For anything?
No, sir.
18 months sentence of the court, 18 months probation. You're to pay $655 fines and court costs, $540 probation oversight fee. You intending on getting out anytime soon, or is this the only one holding you?
Yes, sir.
This is the only case. All right, this is going to be due 60 days after release. I suggest that you contact probation regarding a payment plan. You understand that?
Sir.
There should be no use of alcohol, recreational marijuana, or any illegal substance should be subject to random testing as requested by probation. You're to complete a substance abuse assessment, follow all treatment recommendations with status reports to probation. You are to begin and maintain employment with verification to probation. I will order 365 days in jail, credit 78, balance is suspended. Thank you.
Thank you.
Court does call the case, People versus Brandon Cosa.
Yes, Your Honor, very good. Your Honor, good afternoon. May it please the court, James W. Murray, P48047. I represent Mr. Kirakoza. Please state your full name.
Brandon Kriakosa.
Okay, go ahead. You ready? Go ahead, sir.
Thank you very much, Your Honor. We're here for sentencing. Mr. Kirakoza has read, reviewed, and understands the pre-sentence report. We'd respectfully ask the court to adopt it. Mr. Kirakoza is prepared to pay $104 restitution today, and any further fines and costs, he would respectfully ask for 7 days to pay that.
Is there anything you want to say before I do impose sentence?
No, Your Honor.
Sent to the court, I'll place you on 6 months prosecutor deferred sentence. You're to $425 fines and court costs, $180 probation oversight fees. Pay that by April 3rd, 2026. I'll order $103.94 restitution to tax. That's payable to the court. That should be paid. There should be no use of alcohol, recreational marijuana, or any illegal substance. Should be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 6 weeks. You're to complete 25 hours of community service with proof to probation. No going to any TJ Maxx store in the state of Michigan. I'll set a review hearing that's to be held September 23rd, 2026 at 12 noon. I'll order 90 days in jail. Credit 2. Balance is suspended.
Thank you very much, Your Honor.
Thank you. Court does call the case, People versus James Wilson.
Ron Brown appearing on behalf of James Wilson, Your Honor. Please state your name.
James Wilson.
Your Honor, I've met with him at the jail this morning. I've shared the recommendation. We'd ask the court to follow it. And in terms of the statutory fines and court costs, we make a payment plan.
I don't
out.
Anything about that.
Thank you.
Sir?
Yes, sir.
Anything you want to tell me before I impose sentence?
Sir, it was a big misunderstanding. The officer had pushed me 3 times and I just reacted. I didn't mean to do it. I'm deeply remorseful, sir.
Sentence of the court, $125 statutory, 180 days in jail, credit 141 served. Defendant is to serve the balance.
Thank you.
Thank you. Court does call the case, People versus Haley Garcia.
Good afternoon, Your Honor. Marissa Vogt, 438 on behalf of Ms. Garcia. State your name for the record, please. Haley Garcia.
Very good. Right over.
Yeah.
Go ahead.
We reviewed the PSI. We have no additions, deletions, or corrections. We would ask that you adopt the recommendation. She does have the restitution prepared to pay today, as well as her court fines. And lastly, she would be requesting permission to travel. That'll be from this Saturday to the following Saturday to Florida.
To Florida?
Yes.
From the
28th, I believe.
27th.
To the 28th to the 4th.
28th to the 4th. All right. Ma'am, is there anything you want to say before I impose sentence?
Yeah, I deeply regret what I've done and I take full responsibility. And I'm going to try to do better.
Okay.
I'm sorry.
It's all right. You're all right. That's what we all do in life, right? We just, as we're doing things, we can sometimes make mistakes, but the important thing is
Thank you.
to realize those mistakes, understand best we can why it may have happened, and just sort of promise ourselves and maybe the others around us that we're going to do better.
Yeah.
Right?
Yeah.
We have to do that because we're human. All right. Get that. All right. Sense of the court. Place on 4 months prosecutor deferred sentence. You're to pay $400 fines and costs, $120 probation oversight fees, $1,607.96 restitution to Target payable through the court. If I heard counsel right, you can pay that all today. Pay that today. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class within the next 60 days. You're to complete 25 hours of community service as directed by probation. There's no going to any Target store in the state of Michigan. I've set a review hearing that's to be held July 8, 2026 at 9 a.m. I'll order 90 days in jail. Credit 1, the balance is suspended. I will also indicate that the defendant may travel to Florida March 28th through April 4th. And I've granted that.
Thank you, Your Honor.
Thank you.
Thank you. Court calls case People versus Kyle Zimmerman. Okay.
No cause. Ron Brown appearing on behalf of Kyle Zimmerman.
Kyle Zimmerman.
Your Honor, he's been in and out of custody for about 110 days since the offense date. This is a show cause for pay. Would the
$555.
Yes, sir.
Would the court consider waiving a portion?
In this case, they want to waive it, accept the statement also. Thank you.
Thank you. 125.
Court calls the case People versus Tabitha O'Carroll.
Good afternoon, Your Honor. J. Grant Miller, P58658 on behalf of Ms. O'Carroll.
All right, thank you. Go ahead,
Your
Mr. Miller.
We've gone over the PSIR, and the only addition I would have is to the physical and mental health. We had documented she does have a degenerative memory disorder, and that just wasn't mentioned. That's the only addition we would have.
All right. Ma'am, is there anything you want to tell me before I impose sentence? You're muted, ma'am.
I'm sorry about that.
It's okay.
No, I had nothing else to follow.
Okay.
Your Honor,
It's a
if I could
sentence.
speak as to the recommendations.
Pardon?
If I could speak as to the recommendations, Your Honor.
Yes, go ahead.
I believe the report references she receives $994 a month in food assistance, so we're just asking for any leniency on fines and costs from the court. Ms. O'Carroll's a stay-at-home mother.
It's a sentence of the court, 9 months probationary term. You're to pay $555 fines and costs, $270 probation oversight fees. Do you have any with you, ma'am? Any money you can pay now or no?
Oh, no.
All right. That payment plan as arranged by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to test as requested by probation. You are to attend individual therapy with status reports to probation. You're to complete 25 hours of community service with proof to probation. No going to any Meyer store in the state of Michigan. I'll order 365 days in jail. Credit 2, balance is suspended. Thank you.
Thank you, Your Honor.
Thank you.
Court calls case. You're welcome. Court calls People versus Sandra Armiston.
Ready, Your Honor.
Good afternoon, Your Honor. Attorney Jonathan Paul on behalf of my client. Cassandra, can you turn your camera on, please?
Yeah, she's there.
She's into.